Hey, good morning. How's everyone doing today? We have a Sarah Boone hearing today. We're about a couple weeks before the trial, which is going to happen October 7th, starting with some jury selection. And then, yeah, 2 weeks of trial for Sarah Boone. Initially, it was supposed to be 3 weeks because she was going to go pro se. But then now that she's not representing herself anymore, it's back to 2 weeks. But we'll see. You never know. You never know what happens in a trial. You never know there's going to be any issues that arise that causes it to be longer than what initially should be. But with Sarah Boone today, we actually have a lot of motions to go over today. And I like how James Owens just organized it all for us. You know, I really do appreciate that. We have a motion for a statement of particulars, motion for additional discovery, second motion for additional discovery, amended motion for declaration of indigency. I still can't pronounce that word properly. And payment of due process cause. Amended motion to appoint a forensic psychologist. So that one, we're going to have Dr. Julie Harper. Apparently, she saw Sarah Boone back in 2020, I think, with her former attorney. And since she's already worked with her, James Owens is like, I'm really short on time. Might as well just get her back on the case again. So she's back on the case, and she has declared Sarah Boone as someone who qualifies for battered women syndrome. There's also an amended motion to appoint crime scene reconstructionist and a death investigator, which there are motions already, which we can go to it and take a look at it. So the crime scene reconstructionist, where is that at? So they already found an expert named Dr. Michael Birkland, crime scene reconstructionist, death investigator for the defendant. I think it'll be really interesting to hear him testify about, I don't know what they're going to reconstruct against, like how George got in the suitcase, how George couldn't get out of the suitcase, how he could have zipped himself, or he didn't want to, or he couldn't. I don't know. That's going to be a very interesting testimony indeed. They talked about his costs and how much she should get paid. Now, today we're going to have JAC, I believe, in the hearing as well. So they're going to be approving the costs and everything like that, since Sarah Boone is considered indigent and she does have a pro bono attorney right now. She doesn't have money to pay for all these. So the state, JAC, they need to approve all this. And then we got a motion to appoint a clinical psychologist. So this one is a new one. This wasn't mentioned in the previous hearings. I know that he initially wanted to have two forensic psychologists, one from the Marsha Thompson trial, but it seems like he was unable to get a hold of that expert. So now he wants to have a clinical psychologist to evaluate Sarah Boone. I don't know if they already met, actually. Let's see. Clinical psychologist. We have a doctor, also another Michael, Dr. Michael Brennan, a clinical psychologist for the defendant. Has he met with her yet, though? I don't know if he has or not. I think what they need to do is they need to get the approval from JAC, and then the clinical psychologist can meet with Sarah Boone and then testify. Now, as for Dr. Julie Harper, does it mention Dr. Julie Harper? I could have sworn and mention, maybe it was in a different file then. But hi guys, good morning. How are you doing today? Michaela, she's nuts. Hi Lori, Christine, happy Thursday. Joseph, hello. RP, Chantal, how are you guys doing today? What do you think of the state's response to the battered wife syndrome? We are going to definitely get there in a moment. And then we have a motion. Oh, I thought this was interesting. Motion for the return of property, or an alternative motion for independent exam by the defense. So Sarah Boone was like, the cell phone was taken by law enforcement. Now, I think initially they tried saying that unlawfully it was taken by law enforcement, but it seems like she signed a waiver allowing law enforcement to take a look at her cell phone. And we watched the interrogation where she's like, "Oh, look at my cell phone. It would prove that, this happened to me, or this is how I was treated by George." So there was like, I don't know if they're gonna battle that anymore. It seems like Sarah Boone tried to say that it was taken unlawfully, but maybe that was a lie or something, or maybe it was mistaken. But at this point, James Owen, her new attorney, is like, okay, well, Sarah Boone hasn't had, access to her cell phone. And there's a lot of evidence on there that can really prove that she's a battered, she's someone who qualifies for battered wife syndrome. And then also show that, she was under extensive abuse by George, the alleged victim, And so right now, James Owen put in this motion. There's a lot of motions that was put on, I think, today and yesterday. But James Owens writes this. Defendant Sarah Boone is charged in the above style matter. Boone was arrested on February 25th after giving a statement to law enforcement. At the time, she purportedly consented for her cell phone to be searched, and it was seized. It was purported video evidence from Ms. Boone's cell phone that led to the filing of instant charges. Since February 25th, the defendant has continuously been in custody in the Orange County Jail without bond. Neither she nor her attorneys, now remember that sentence, neither she or her attorneys had the opportunity to see and review her cell phone or to have it analyzed by an independent person or the defense team. Counsel on behalf of Ms. Boone have timely filed a notice of intent to use battered spouse defense. Much of the evidence supporting Ms. Boone's defense, including but not necessarily limited to battered spouse, is contained in her cell phone, including documentation to support this defense. The information contained in her cell phone includes, but is not limited to, text messages, photographs. Additionally, and perhaps as essential to her defense, it is other potential evidence such as witnesses' name and contact information. So they're saying that Sarah Boone hasn't had access to her cell phone, but if you guys remember, the state provided Sarah Boone with the digital evidence, and she asked about getting her cell phone back, and they're like, well, I mean, we kind of, we did an extraction. You got the Cellbrite extraction. Anything that you need in your cell phone should be in that digital report right there. So I don't know if they're still saying that they don't have access to those pictures, those videos. I don't know if the contacts would be loaded over in the Cellbrite stuff, but I mean, I feel like at least you should have the pictures and the videos and like access to the text messages. But it seems like they're saying that they don't have access to it. Now, they either want access to the actual cell phone or they want to have another, independent examination done by one of the defense expert. The state did respond to this, which I thought was interesting. Where is it? The state. Okay, state's response to defendant's motion to return of property or an alternative motion for independent exam by defense. The defendant's assertion that her prior plethora of attorneys had no opportunity to see, review her cell phone is patently false. If they never chose to avail themselves or retain a digital forensic expert, or if the opportunity to inspect the phone, it was of their own volition. Number 2, the digital imaging of the phone has been disclosed in discovery. The defendant can choose to attempt to enter portions of the digital imaging, like the state at trial. The state will introduce the physical evidence into evidence at trial. While it appears to be axiomatic that a court cannot order the state to release evidence intended to introduce at trial, it apparently bears repeating. As a matter of the course, courts should not order the state to return property lawfully seized pursuant to a valid search warrant where the state is actively conducting a prosecution. So the judge is going to review the motions, the responses, and he'll make his decision in regards to what's going to happen to the cell phone. If Sarah Boone had all the stuff that she needed on the cell phone, if they're going to give her the physical cell phone, we'll see what happens with that. What else do we got for today? And then, lastly, so the amended notice of intent to rely on the defense of battered spouse syndrome. This we covered in the previous streams, and also we made some videos about this as well. So Sarah Boone met with Dr. Julie Harper again recently, and Dr. Julie Harper was like, okay, you know what? You qualify for someone who would be, qualify someone as a battered spouse syndrome. Here is the state's response. So I'm trying to go through this as fast as I can because the hearing is popping up soon. I'm sorry if I'm reading this a little too fast. If I am, just slow it down. My apologies. So here's the state's response. The defendant filed an amended notice of intent to rely on the defense of battered spouse syndrome on September 15. The defendant was provided discovery over 4 years ago. By the defendant's own admission, her expert, Dr. Julie Harper, saw her in 2020. So I wonder if Dr. Julie Harper met her back in 2020, saw her 6 times, why did Dr. Julie Harper not qualify Sarah Boone as a battered spouse back then? Or did it not? What was going on there, I guess, is what I'm wondering. Number 4, the discovery in this case shows that the decedent and the defendant engage in alcohol-infused spats of violence against one another periodically. Number 5, this no more describes the criteria for battered spouse syndrome than a mental illness describe insanity under the M'Naughton rule. Wait, what? This no more describes the criteria for battered spouse syndrome than a mental illness describes insanity under the I gotta look that up later on. Number 6, the conclusory statement that, in quotations, in particular, the evidence will demonstrate factors that will trigger BWS, or battered wife syndrome, the physical symptoms experienced during BWS, the distinct behavioral and psychological symptoms exhibited by the defendant that are consistent with a person who suffers from BWS, and the impact of BWS as it relates to the facts of this case does not set forth a particular evidence that shows the defendant suffered from this syndrome. Number 7, the state's concern that the defendant is alleging does not meet the criteria for battered spouse syndrome is not premature. Discovery does not support a diagnosis of battered spouse syndrome, and the defendant has not alleged new facts to support battered spouse syndrome. Number 8, battered spouse syndrome is not actually a defense to a crime. Now, remember, Sarah Boone said that she accidentally forgot and left him in the suitcase and she went to sleep. I think the state in a different motion was saying that, like, okay, well, did you forget? Or are you trying to say that, your defense is that, you're a battered spouse? It's like, which one is it? The introduction of battered spouse syndrome evidence to support a self-defense theory is not for the purpose of justifying a defendant's misperception of reality or to explain why an unreasonable belief was nonetheless justifiable due to her condition. Rather, the Florida Supreme Court has sanctioned the use of battered spouse syndrome to show why the defendant's actions were reasonable. Yeah, George was found in a suitcase. To show in spite of a reasonable perception of danger from the battering spouse. The battered defendant would remain in the home with her batterer, where she may resort to the exertion of force against him to prevent imminent death or great bodily harm. Number 9, there is no evidence of a justifiable use of deadly force in this case, and the defendant has not alleged any such new evidence in her notice of her intent to rely on battered spouse syndrome. Number 10, what the defendant told the law enforcement was, A, when asked about a decedent's other's injuries, in all honesty, we haven't gotten into it. Statement 22520. I think these are from the interrogations. The defendant said that she and the decedent were having a good time on Sunday, having wine, painting, doing puzzles, listening to music. Nobody laid a hand on nobody. I do remember that. I wonder if they're going to cite the hide and go seek shit. Letter C. I have not touched him. We had a good day. It was a good day. We had good days lately. Statement 2520. And I think if you guys remember, the property manager said that things were very chaotic between George and Sarah Boone. They had a lot of people, a lot of other neighbors reporting them for noise complaints and other issues on the property. And then she said that she had a talk with Sarah Boone, and it seems like things were a lot better. And then the suitcase thing happened. So I think this could correspond with, things at some point were getting pretty okay and more calm with Sarah Boone and George. But then, something happened that night where George got in the suitcase and Sarah Boone took that opportunity to probably just let him suffer. Letter D, there was no ill will between us last night. E, last argument was maybe last week. F, I was so happy, like it was such a good day. I kid you not. Oh my God, these are a lot of statements. G, nobody touched nobody. Nobody touched nobody. H, it's a drinking. That's what it is. It's a drinking. I thought he was okay. I, everything was fine and dandy. J, question, why didn't you just let him out? Answer, to be honest with you, I don't know. K, I will never drink alcohol again. Q, or question, what was your motivation for leaving him in the bag? Answer, I didn't have any motivation. It was me, he and I were having a good day, fooling around, being stupid. Apparently me going upstairs and I'm blaming it on wine. Question, you two didn't lay hands on each other? Answer, no. No. N, I don't have any injuries. He and I have not been at it with one another. O, she didn't do this intentionally. Alcohol is a shitty thing. P, so it's like, okay, so we're in a good place right now. I'm going to snap. Is that what it is? What does that say? Hold on, let me see. They're not back yet, right? Okay, hold on, we're almost done. So it's like, okay, well, we're in a good place right now. I'm going to snap. Is that what it? I don't know. Well, we're in a good place right now. Q. See, that's the thing too, but you can clearly tell that I have been drinking some. R. I didn't touch him, nor did he touch me. 11. The defendant's account is not one of self-defense, but rather an accident. And that's what she said in the body cam. And it seems like in the interrogation from all those. This is from the interrogation, I think, right? BSS is not itself a legal defense, but evidence that the defendant suffers from BSS is admissible in Florida to support a claim of self-defense when the defendant is charged with a crime against her abuser. If the defendant has changed her account, which she has not alleged such in her amended notice of intent to rely on battered spouse syndrome evidence. 12. Therefore, the state renews its request for the court to strike the defendant's amended notice of intent to rely on the defense of battered spouse syndrome. It does not set forth with particularity the evidence that would show the defendant meets the criteria. 13. Man, and this is the main crux of Sarah Boone's defense right now, that they're going to rely on battered spouse defense. And I think this is something that other previous attorneys try adopting as well, but we had issues and they end up dropping out. 13. Additionally, the state renews its request to prevent any mention of battered spouse syndrome until admissible evidence of a justifiable use of deadly force is admitted into evidence at trial, and admissible evidence of battered spouse syndrome is admitted into evidence at trial. Thus far, the state is aware of no evidence supporting the defendant suffering from the syndrome, only evidence of alcohol-induced violence between both the decedent and the defendant. There is zero evidence that this was a justifiable use of deadly force. The defendant has stated the exact opposite, and she's the only one who can testify that it was a justifiable use of deadly force. Hey, Mari. Mari, thank you so much for the 2. Maybe both batterers, but who won? Question mark. Women do it too. Mari, thank you so much. I appreciate it. From what I've seen so far, it seems like they were both very violent towards each other. I don't know who would started, but maybe I'm making a lot of assumptions here, but I could totally see Sarah being the type of person who would just egg it on. Based on what we heard from other witnesses, it seems like, maybe she was the aggressor. Maybe George tried to get away. And maybe at some point, George was just also really drunk too, and George would go after her. But I mean, I've seen some of the police reports. They were both arrested at some point or beating on each other as well. So it seems like, when they would get drunk, things would go pretty fucking wild. And they were, horrible alcoholics. Their family, well, at least George's side of the family tried to get him to stop drinking, and he knew he had a drinking issue. For Sarah Boone's side of the family, I mean, I haven't really heard, aside from Brian Boone, her ex-husband, we haven't really heard from anyone else on the Sarah Boone side of the family. Frosted Dreams, hey, thank you so much for catching a live. How's it going? All right, we're just waiting. Sarah Boone's in the court. I'm gonna boost audio up. So Sarah Boone has, I think, 3 attorneys representing her right now. We have Mr. James Owens, and then there are 2 other co-counsels that are assisting. One from New Mexico, and then one from Florida. I think James Owens is going to be in the courtroom today, and then the other co-counsels, I think they're just going to be dialing on Zoom. Also, the woman next to Sarah Boone, I thought she looked like Hailey Bieber for a second. Yeah, so you guys were telling me to watch Brian Boone's interrogation. I think I'm planning on doing that next week. Let's do all the interrogation, the body cam videos all next week. So I'm going to be in Hawaii for a wedding, and then I'll be back on Monday. We're going to go quick in, quick out. All right, we lost the feed. I'm sure they'll come back. How was your guys' weekend, though? How are you? Oh, last one. Defendant's motion for enlargement of time. That is such an interesting way to phrase it. Enlargement of time. So the defense was like, hey, I'm on this case, and there's a lot of stuff going on. Can we just make it so I can object to the state's evidence? Could we just extend that deadline? That's basically what it is. But we have a lot of stuff here, and I really appreciate Mr. James Owens organizing it all like this. I like organization. Does Sarah have family other than her brother? I don't know. I do not know. I don't know if her parents are still around. For some reason, I thought she had another brother. Like, I thought she had 2 brothers, but I'm not quite sure. Wow, I didn't expect Sarah to go from pro se to having a whole legal team. Hi, Tam Tam. How's it going? Case number 20. Sorry, court's audio. Judge, I'm James Owens. I represent Sarah Boone. Oh my God, what is his audio? Hold on. Oh my God, what is going on? Lord Crime, help us! Is it better? Okay, I think it's better now. I'm on my iPad to make sure. No?
I'm going to moot Messrs. Beck and Henderson for the moment. We seem to be getting some feedback.
Beck and Henderson are the co-consuls.
If they need to speak, we can address that if and when that's necessary.
Come on, Beck. Come on, Henderson. Get your audio stuff sorted.
On a litany of hearings, the court did receive the state's response to the motion to return property, which just filed yesterday.
The cell phone?
And the state's amended notice or amended motion to strike the amended notice of battered spouse defense. The court was reviewing the authorities cited therein, which is why we're a few minutes late this afternoon. Are there any housekeeping matters, state, that we need to address before we begin this afternoon?
Not from the state.
All right. Any housekeeping matters from your side of the ledger, Mr. Owens?
Judge, I appreciate being here, and I just wanted to introduce my 2 assistants that are helping me, Shelby Andrews and Lauren Henderson.
Afternoon, y'all. Anything else, sir?
No.
Okay. To the extent we may be hearing from Ms. Boone, ma'am, if you could, please raise your right hand. Madam Clerk's going to go ahead and swear you in. I believe that the first thing that was filed in this case, just as a matter of time, was the state's motion to, the defendant's motion for statement of particulars. That was filed on September 2. I've reviewed that. Mr. Owens, you may proceed, sir.
Judge, do you want me at the podium?
However you feel most comfortable, sir, but because we have your co-counsel appearing virtually, I would ask that you direct any argument into the microphone so that they might be able to hear it, sir.
Us too, please. We would love to hear. Hi,
Judge,
Forky.
as you know, I filed on behalf of Sarah Boone this motion for statement of particulars, and in my motion, I quoted the language in the information that she was charged with, and the pertinent part charges Sarah Boone on the 23rd day of February of 2020 in said county, Orange County, violated statute 782.04, paragraph 2, by an act eminently dangerous to another and evincing a depraved mind regardless of human life, did kill George Torres. Judge, that's about as bare bones of an information as you can file in a case. I know any time there is a weapon used, it's usually shot with a firearm that was used, that type of language. That is as bare bones. It doesn't even spell out all the essential language of the jury instruction, which I followed. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, the victim is dead. 2, the
Oh, I can make it louder for you guys. I'll use my booster.
death was caused by the criminal act of the defendant. Now, there is no language in the information that alleges what criminal act Sarah Boone committed that caused the death of the victim, Mr. Torres. This is a unique case, Judge. It does not involve a firearm,
Okay.
which I believe many of these cases do. I'm sure you're well aware, the state's well aware, the defense is well aware of the report, the videotapes in this case, and the overall general facts about the suitcase and Mr. Torres being in the suitcase asking to be let out by Ms. Boone. But the state, in their charging document, has failed to say exactly what it is that they believe is the criminal act that caused the death by Sarah Boone. Some information that the defense could receive from them so that we could properly prepare a defense for Ms. Boone. In count 3, the unlawful killing of the victim was an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. It goes on to define an act as a series of related actions arising from or performed pursuant to a single design or purpose. We have no information, no particulars in the information that explains a series of related actions arising from and performed pursuant to a single design or purpose. None of that language is in the information that would let us know what it is they're claiming that she did or series of acts that she committed that constituted the cause of the death of Mr. Torres. The definition goes on to explain that an act is eminently dangerous to another or demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. What is the act or series of acts that an ordinary person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury? 2, is done with ill will, hatred, spite, or evil intent. What acts or actions by the defendant did they present, or will they intend on presenting in the trial, that would tend to indicate that she had ill will, hatred, spite, or evil intent towards Mr. Torres? And 3, is of such a nature that the act itself indicates an indifference to human life? Again, some explanation that give the defense, my understanding of the rule of criminal procedure, the defendant has a right to know the charges against them with specificity. Upon request, the state must provide specificity and clarification on the details of the alleged offense in order to minimize surprise at trial and ensure that the defendant's rights are protected. The rule requires that the information shall, in plain, concise, and definite written statement of the essential facts constituting the offense charged. In this case, based on the bare bones information that has been filed in this case, it fails to inform the defendant and the defense counsel of the particulars sufficiently to enable the defendant to prepare a defense. Thank you.
Response.
Because I guess, okay, so from us watching the video and then from us seeing the, what was summed up in the autopsy report, it was shown that he was left the suitcase and then he eventually died of just, is it like asphyxiation? Is that the exact term that they use? I forgot what it was. But it's like, okay, I mean, it's kind of already there. But I guess what he's saying is that he wants it all written down. He wants to be very specific. But it's like, I don't know, I guess to us it seems like common sense, but he just wants it to be formally written so he knows exactly what the state is saying? Question mark? Is he just trying to figure out ways to blame the state for things in order to get a continuance?
Judge, the state stands by its written response that was filed on September 5th of this year. In addition to that authority that is cited therein, the state would also cite State versus Pajon, P-A-J-O-N, 374 Southern 2nd, 1070, Florida 3rd DCA, 1979, and Sutherland versus State, 305 Southern 3rd, 776, Florida 1st DCA, 2020.
Can I have the second citation again? 305 Southern 2nd.
Southern 3rd, 776. And what all these authorities stand for, dating back to well before there were any discovery rules crafted in, I think, 1968, is
Bruises.
the position that it's an extraordinary remedy to be given a statement of particulars in a case. The information in this case tracks the statute. That is what is required. There is nothing confusing about it. There aren't multiple allegations of second-degree murder on the same day, leaving her confused as to what we are talking about. There is no exposure to double jeopardy. There is no element of surprise. The state of Florida has provided discovery to the defendant in 2020. The state waived any opinion work product arguments that it had under Williams versus State in going ahead and providing the defendant exactly which exhibits we're going to enter in a trial, exactly which of the witnesses we've disclosed will be called at trial. And their motion does not set forth why it is specifically that they don't understand what she is accused of doing and how. In fact, opposing...
I mean, it seems pretty straightforward based on what we've seen so far.
Counsel cited the videotapes, the videos that were taken on her phone while the decedent was in the suitcase begging to be left out. And then what they didn't mention is what she said during these videotapes, which certainly would constitute the mens rea for second-degree murder. So it's our position that they have not stated why it is that a statement of particulars is necessary. It's an extraordinary remedy. They have all the discovery. Not only do they have all the discovery, they have the narrowed down list specifically as to what will be introduced, and they are clearly on notice of what constitutes the acts and the mens rea, because they have mentioned those videos that were taken on her phone. So it's our position that this is not one of those extraordinary cases that necessitates a statement of particulars. There are cases where, for example, somebody commits multiple acts of battery against a victim, perhaps an hour apart, 2 hours apart, and comes back, and it's unclear as to what the state is talking about. counts 1, 2, and 3 all say battery on X day. There are informations and indictments that span years that don't get statements of particulars articulated to the defense. In this case, the date is specific as to February 23rd, 2020. The metadata on the 2 videos that were taken from her phone are both from the 11 p.m. hour of February 23rd, 2020. Given all the discovery in the case and the amount of narrowing down that we've already done, there is no need for a statement of particulars in this case. Thank you.
Thank you. Any response?
My understanding of the law is the court has broad discretion on this issue about whether to require the state attorney's office to give more particulars about the offense. And this is somewhat of a unique case, and the state attorney just mentioned where there was prior incidences of violence or battery that occurred prior maybe to the death, and whether or not that was relevant or admissible. That's the case we have here. Judge, I'm sure you're aware that Mr. Torres suffered from some blunt force trauma that was unrelated to the death. The medical examiner who did the autopsy took photographs and described that there was blunt force trauma on Mr. Torres's body that did not cause the death, that was unrelated to the cause of death. And that information has not been detailed whether or not it's relevant to his death, whether or not they're going to try to tie that in to Mr. Torres's death. And if not, if we're relying on the medical examiner's explanation of the cause of death, which was asphyxiation, suffocation, then there's a question about whether that information is...
But is there anything that's missing under the statute? I understand your reliance on the jury instructions, but what's your response to Mr. J's position that it tracks the language of the statute wholly and completely, which it seems to?
Well, I have the rule for motion of particulars then. If that's the case, then in every case in the country, you just have to track the statute, and at no time a court would ever order a motion for statement of particulars.
But the date's there, the time's there, where it happened is there, the underlying charge is there.
I understand, and I explained that this is not a shooting where death would occur fairly quickly after multiple shots, that this was an unusual death, asphyxiation over a period of time, which we don't even know whether it was the day before or the next day. There's questions about that. The injuries, the blunt force trauma that the medical examiner is claiming that they're there, I believe is going to testify they could have been there 24 to 36 hours before. We don't know when those prior injuries were. They're fairly fresh, but they can't state that they were close to the time of death. Again, they weren't related to the cause of death. So there are situations...
I mean, the state was going by off of what Sarah Boone was saying in the interrogation, because she was saying they were having a good time, they weren't fighting, no one's hitting each other. So you could assume that those bruises may have happened when he was in the suitcase, and maybe she was pushing him around while he was still in the suitcase.
In the law, based on the unique set of facts that a court feels compelled, yeah, I have the discretion and I feel like for the defense to properly prepare for this case due to this unique set of facts that I think there are some details that you must give. There's blunt force trauma. We don't know exactly when it was. We know it was fairly recent. And the medical examiner says the cause of death is asphyxiation. He doesn't know where it was environmental or not. He gives two explanations. So there's a real question about that. And, of course, we'd like to know what theory they're going under and whether or not they're intending to introduce evidence of this blunt force trauma that occurred sometime prior and what exactly they're claiming that she did that constitute. Is it just the video, the 2-minute video that everybody's seen, or the suitcase video? Is it that? Because there was a lot that occurred prior to the video. There was a lot that occurred after the video that's not on the video. So is that what they're referring to in this narrow window of just tracking the statute? And I go back to, there wouldn't be this rule in the criminal procedure if there wasn't a time when a statement of particulars was necessary. Okay. Thank you.
All right, thank you, sir. The court has reviewed the motion, reviewed the authorities provided, including the additional authorities, State v. Pajan, 374 Southern 2nd, 1070, and Sutherland v. State, 305 Southern 3rd, 776, and relying on State v. Peel if the indictment is sufficiently full in its allegations of fact constituting the crime charged to enable a person to plead to it, the greater part of the reason for allowing particulars does not exist. The application was not so much for a bill of particulars as for a detailed statement of the evidence by which the state proposed to prove its case. If the defendant was advised of the nature and the cause of the accusation against him and had notice of the dates on which the acts constituting the offense were committed, there was no necessity for the bill of particulars. All of this information was given in the indictment. And that is at 154 Southern 2nd, pinpoint 912. It sounds like, based on your argument, you're looking for the particular evidence as to the cause of death and the meaning of the death, which, based on Peel, is not something that falls under the ambit of a motion for particulars. So reliance on State v. Peel, understanding the age of this case as well, understanding there have been multiple lawyers who have filed responses denying the charges in their notices of appearance, your motion is denied, looking at the totality of the circumstances.
Thank you.
Because the judge says we got a date, we got a time, we got the where, the underlying charge.
Moving now to, give me a moment. And I think we could probably address these collectively. The defense's motion for additional discovery filed September 2, and the defense's second motion for additional discovery filed September 6th. Similar to the first motion, the court has reviewed all the authorities and those motions. Mr. Owens, you may proceed, sir.
Can I approach the bench?
Yes.
Motion for additional discovery was filed on September the 2nd at 8:30, and then the second motion for additional discovery was filed on September the 6th. The first motion refers to the rule 3.220F for additional discovery. On a showing of materiality, the court may require such other discovery to the parties as justice may require. Specifically, the defense is requesting the Office of the State Attorney to provide a written policy of the Orange County Sheriff's Office relating to in-house interrogation procedures, in particular the policy in place at the time of the interrogation of the defendant at the Orange County Sheriff's Office, which was back in February of 2020. And then the second motion for additional discovery, specifically, the defense requests the Office of the State Attorney to provide the standardized Miranda rights written policy, the form.
Oh, him wanting the policy was so interesting, because I was like, couldn't you just contact the sheriff's office and just get it from them directly? And I think that's what the state said exactly. It's like, did he even try to get this on his own before asking us to do it?
And the card of the Orange County Sheriff's Office relating to Miranda rights form utilized and read directly to any suspect before any interrogation. Now, the argument by the state is well taken. The defense does have a duty to try to gather the information independently of the state attorney's office. And we did make a request to the Orange County Sheriff's Department back on September the 10th. And the request was for the written policies and procedures of the Orange County Sheriff's Office relating to the in-house interrogation procedures, in particular the policies and procedures in place in February of 2020, and the written policies number 2 and procedures of the Orange County Sheriff's regarding Miranda rights, written policy, the form and the card relating to Miranda rights utilized and read directly to the suspect before any interrogation in effect in February of 2020. So as you know, Judge, I don't know if you've actually watched the 2-hour interrogation, but the day after this event, she was asked to come down to the Orange County Sheriff's Office under what my client believed was something other than an interrogation. When she got there, she was directed into a room, and I don't know.
Really? She went there thinking she wasn't going to be interrogated? Really?
Said you haven't had a chance, but there are some serious issues about whether or not that was coerced, whether or not Miranda rights were fully read. I do not believe they were. I believe some of the statements that the lead detective said before she started the Miranda rights are coercive. She was in a room where she could not leave with 2 homicide detectives. One was wearing a firearm, and she acquiesced to authority based on an improper reading of Miranda. I wanted to file motions to that effect. We've got trial coming up October the 7th. I wanted to wait to get those policies. I wanted to wait to get the Miranda rights forms. The homicide detective actually reads it from a card. And I believe she read it incorrectly, and she left out the main question at the end. So the proper thing to do is to get that information and make sure it's verified before you file in good faith a motion to suppress her statements. Well, the state attorney has tremendous power. I've made this request, September the 10th. Now it's, the 19th. And I'm in line with other public records requests there at the Orange County Sheriff's Department as to when I get this information. The state attorney could have gotten it the very next day if they would have made that request. That's why I filed the specific motion for the additional evidence. Time was of the essence. The court denied my motion on September 3rd to continue the case. We've got about 18 or 19 days left for trial.
I think he's trying really hard to get this continuance.
Still waiting.
Okay.
I've still got to receive that information. I've got to file the motion. I've got to set it for a hearing. I've got to subpoena the 2 detectives, the 2 homicide detectives. We've got to have a hearing with 18, 19 days left. I'm still waiting on this information from the sheriff. I've made a good faith attempt. Time is ticking. The state could get that information to me tomorrow. Thank you.
Response.
Your Honor, it's not Mr. Owens who's on trial, it's Sarah Boone. Sarah Boone was interviewed by the Orange County Sheriff's Office on February 24th and 25th of 2020. Now, some 4 years and 7 months later, there's this exigency not created by us, created by them. It's the defendant who has not done this for 4 years and 7 months.
Yikes.
Now, turning to the merits of this, they are asking for discovery from a third party. Any discovery request, whether it is of the state or of a third party, has to involve allegations that this information is reasonably calculated to lead to admissible evidence or be pertinent to some analysis in this case. They have not stated why in their motion, and the arguments in court today do not state why it's pertinent either. The case law does not say statements are inadmissible or only used for impeachment if the law enforcement officer violates policy. There's no case law that says statements are inadmissible or only used for impeachment purposes if they don't read from their Miranda card properly. What the case law states is statements are inadmissible if there are Miranda violations and only used for impeachment, or if statements are involuntary, basically through promises, then they can't be used for any reason. But nowhere in this analysis does it matter to any degree what a standard issued Miranda rights card looks like or what their policy is on interviewing. What they do have and what the defendant has had since February or April or whenever discovery went out in 2020 was a videotape of these interviews. There has been absolutely nothing stopping anybody from filing a motion to suppress if they believed under the case law relief could be granted under the law. And the law does not have any analysis regarding standardized issued Miranda cards or policies of law enforcement agencies. And I don't believe that's admissible at trial either. If they did not violate the Constitution of the state of Florida or the United States in compelling an involuntary statement or by violating the dictates of Miranda versus Arizona, then questions about whether they read from their right standard card or if they violated policy should not be admitted in trial because it does not help the jury understand whether or not an element of the crime has been proven. It's not a part of the lengthy jury instruction now that we give about defendants' statements. There's nothing in there about, well, did they violate their Miranda card? Did they violate their policy? So first of all, the state's position is they have not asserted the materiality needed to get discovery ordered by this court, which would be reasonably calculated to lead to admissible evidence or to lead to it being found inadmissible by the court. And then secondly, it's on them to conduct this discovery, and coming in and saying that I can snap my fingers or not snap my fingers and get it for them instantly isn't evidence either. So it's our position that their request should be denied, primarily because it's immaterial, and then secondarily because it's on them. She's been aware of these statements since February 24th and February 25th of 2020. Thank you.
Thank you. Response to the materiality, please.
Ooh, specifics.
Judge, I believe the prosecutor is wrong. One of the jury instructions, standard jury instruction in criminal cases said that essentially a statement has been placed before you that's made by the defendant. And I don't have the language here, but it should be weighed with great care and caution to make sure it was freely and voluntarily made. These are some, but not all of the circumstances that you should consider in deciding whether or not the statement that was made by the defendant was freely and voluntarily made. If you decide that it was not freely and voluntarily made, that evidence should not be considered by you in this cause. So even if we filed the motion, we got the information, the additional discovery that we need in good faith for me to file it, if we received the information, I typed up the motion, we had a hearing, the two detectives testified, and the court ruled that the statements were not suppressible, I could still bring those facts into the trial of how the mistakes that were made by this lead detective in the coercive statements that she made, as well as not giving the full Miranda rights form and getting a full consent from my client, that goes into evidence for the jury to decide whether or not to consider the statement at all. Thank you.
So where's the violation of the Constitution then? Assuming you're correct, and assuming that the Miranda card, something was missing, what's the issue?
It's coercive. The statements that the lead detective, the female detective makes, there's 2 or 3 statements she makes.
Now you have to understand, I'm in a vacuum here, because I haven't watched the video. I'm not asking you to play it.
I probably should have.
But I need a little bit more context as to these statements, because I have unfortunately no frame of reference.
But she says that, number one, the date of this event, they seized her phone at the scene. She was told that they were going to bring her phone back to her, back at her apartment, the very next afternoon. The female detective called her, or Sarah called the female detective about the phone. The female detective said, I'm pregnant, I'm not feeling well, I don't want to drive out there to give you your phone. Would you please come to the sheriff's department so that we can give you your phone? Sarah Boone got there and saw that there was a desk or a place there to retrieve the items, and she saw the male detective and said, is this where I go to get the phone? He said, no, we got it back here in this room. Come back here in this room and we'll get it. When they walk back in there is when the video turns on, and now they're in the interrogation room. She's got a list. Sarah Boone has a list of things that she was wanting to ask them. And the female detective says, look, we got the autopsy back from the medical examiner. We've got to talk to you about that.
I mean, it seems like Sarah Boone knew that she was going to speak to the investigators because she had a list of things that she wanted to go over with them. It's not like she's just going to go there, pick up her phone, and then dip out. It was like, oh, I know there's going to be a conversation between me and the detectives. Here's my list of things I want to cover with them.
She said, we must, I don't think it's must, we've got about that. 2 times she said, we must, I don't think it's must, we've got to talk to you. She goes, okay. Said, I got to read you these Miranda rights again. And Again, she had read them. There was a statement that Sarah Boone gave. Of course, she gave a general statement to the first deputy that responded to the scene. She was wearing a body cam, so that deputy had called the 2 homicide detectives, but it took them a while to get there. So she asked Sarah Boone what had happened, and Sarah explained that situation. After the detectives got there, they took a general statement from Sarah, but at some point they got into one of the squad cars. and I believe it was Sarah Boone, I believe it was the female detective and the male detective, and she was read Miranda rights, again, incorrectly, and she gave a statement. So now the next day, she's back in the interrogation room with the two deputies, the two detectives, and the lead detective says, we've got to talk to you about this autopsy, giving her the impression that's what they were going to talk about.
I don't think we have a picture, a video of her in the car, right? I remember when they were asking for her cell phone, and then the body cam video just ends there.
I have to go out and do it. Plus, there's stuff that I
But
run.
I've got to read you these Miranda rights. And she said something, and Sarah said protocol, because they had told her in the first Miranda rights that this is just protocol. We have to do this before we speak to you. And she said, yes, protocol. So based on those statements that we've got to talk, you have to talk to us, we've got the autopsy, led Sarah to believe that they're going to talk about the autopsy. In addition, then she starts in the Miranda, judge, she made a mistake on it. I don't know if it's an anonymous mistake, but in her probable cause statement, she said, I read the rights verbatim. The constitutional Miranda rights, I read to her verbatim. That is not true. Fortunately, we have it on audio. Fortunately, we have it on video.
Sorry, do you guys mind if I just segue here really quick, just so we have a refresher?
Appreciate you coming in.
Yes, ma'am. Can I want to ask you about these whenever we have a moment.
Sure. So obviously, he received his autopsy. So I'm going to read you your rights again because we have to talk about that. And since I'm talking about
I'm going to read you your rights again, okay?
the incident, we just have to do it, just like we did yesterday.
Protocol?
Just like we did yesterday. Remember I read you the rights? Your rights? Yeah. So it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay?
Sure.
All right, so you have the right to remain silent. Anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me?
No.
And do you understand what I just read you?
Yes.
Perfect. Okay. So,
Okay.
There is a legitimate question about whether that statement, that 2-hour interrogation, is admissible in this trial. That's what I'm going to show the court. I'd like to get their policy just to see.
What does the policy have to do if those statements were inadmissible? What does the policy have anything to do with that analysis?
To see if they...
Because if you're saying you have a deposition, I'm assuming it's a deposition of the female detective, said I read it verbatim, and you're telling...
That's in the probable cause statement.
Okay, that it was read verbatim. Okay,
Yes,
excuse
they
me.
formulated the arrest report. It was a supplemental report or either the actual probable cause report.
And the representation in there is, it was read verbatim.
That's correct.
Now, you've reviewed that interrogation. It's your position that it was not read verbatim. What does the policy have anything to do with that issue?
I think
that's a simple constitutional issue, right?
Yes.
If there's a case law that buttresses that position, and that de facto is a violation of the Constitution, ergo, that confession or statements are not admissible because of the violation of the Constitution. What does the policy or the Miranda card have anything to do with anything if you have the video and the audio?
Well, the Miranda card is going to show that she actually omitted the last question. Okay? So the Miranda card is there for a reason. I don't know if they have them in the interrogation room or every deputy or homicide detective is issued that card, but it's a small
Me and the judge
card.
right now.
But I believe it's going to say on there that you've got to get the waiver. There's 2 questions at the end, which is, did you understand the rights that I've just read to you? And the next question, understanding these rights, do you agree to speak with us now? That question was not read. It was omitted. I don't know why. She's sitting there reading it, and
Does the fact that that question was not read impact constitutionally under case law the admissibility of those statements?
I believe so, along
That doesn't
with
answer
her
my
other 2
question.
statements.
Respectfully, that doesn't answer my question. I understand what your belief is, but where's the case law that you can provide to the court?
I'm not ready for that, Judge.
Okay.
I'm going to file a motion to suppress, and I'll supply you with the case law, but
You're not ready for that, but then you filed this motion back in September 2nd with the second motion on September 6th. What do you mean you're not ready for that? Come on now, when you make these arguments, you gotta got the case law to back you up. That's where the judge is like,
I'm not ready for that. But the reason I wanted the policy, getting back to your first question, is because I'm sure the policy is going to say you don't make any pre-Miranda statements like, we've got to talk. We've got to talk about this autopsy.
like you gotta work 2 steps ahead. You gotta anticipate this is what's gonna happen. I think he just thought that maybe the judge was gonna make a big issue about, him not getting his policies and procedures from the sheriff's office, and it was just gonna go from there. But he should have anticipated the judge denying it and then him expecting to explain, okay, so like, I don't care what you think, but I want you to explain to me, is there any case law that backs up what you're saying? And the judge right now, it does not look like he's happy. Look at his face. He's like sitting like this. He ain't looking happy. He doesn't look happy at all.
Those type statements are improper, that they're used to coerce somebody to talk. And I understand the detective. They had these videos, the 2-minute video and the short second video, and they had found it on her phone. So the homicide detective was chewing at the bit to get her to talk. So she was trying to induce or influence her to speak to them and to not exercise a fundamental right, not to speak to them without a lawyer being present. So she made those 2 statements preliminarily that I believe the policy is going to say you don't do.
Okay. Mr. J, anything else, sir?
Just, the Orange County Sheriff's Office doesn't set the policy for what is admissible evidence in the court. The United States Supreme Court does, the Florida Supreme Court does, the 6 DCA courts do, and then ultimately, following their guidance, you will decide whether or not a statement is admissible in the state's case in chief or if it's only available for impeachment. But whether or not, let's say hypothetically, she read the Miranda card 100% accurately, she followed policy 100% accurately, the state of Florida can't come in and say, Judge, I know they violated U.S. Supreme Court case law, but they followed the sheriff's office's policy, so these statements are clearly admissible. And the contrast is exactly the same. Whether or not they followed policy or read the Miranda card accurately has nothing to do with the analysis as to whether these statements are going to be admissible or only admissible for impeachment. And I don't believe that under the case law, they can come in, if those statements are admissible, and argue to the jury, they violated policy. They didn't review, they didn't read everything on their card. They violated. How does that help the jury decide whether or not the statement's voluntary? It doesn't matter what the policy is. It doesn't matter what the card is. What matters is whether or not they say the words that are required by the United States Supreme Court or the Florida Supreme Court or the 6 DCAs. That's what matters. That is what determines the bar for the admissibility in the case in chief or an impeachment.
Okay, thank you. All right, thank you both for your arguments and your positions. In reviewing the authority provided by the state, which the defense has conceded is taken in, is what it is, I think State versus Wright is the guiding light for the court here, 803 Southern 2nd, 379. In reviewing that analysis, the defense has put forth an effort to do so. It's not up to the state to prove up anything for the defense. At this point in time, both motions for additional discovery are denied in accordance with State v. Wright. Moving now to the defense's motion to appoint forensic psychologist filed September 2, and defense's motion to appoint crime scene reconstructionist and death investigator filed September 2. I did receive JACS's response in that my judicial assistant confirmed that they are
who finally gets some motions not denied?
not asking to participate in this hearing. And we did confirm that earlier this week.
Oh, they don't want to participate? Why?
Similar to the other motions that we've heard today, I have reviewed them. Mr. Owens, you may proceed with anything else, sir.
Judge,
I did see that, sir.
and then there are 3 motions. I don't know if you got the third one. No, relating to cost. Relating to cost.
Don't know that I have. I'm just going by what the notice of hearing reflected, so no, I don't.
I filed a second amended notice of hearing. I don't know if you got that.
Was it forwarded to my office? Because if it wasn't, I don't know.
I'll
that I
have to
got it
ask
yet.
Margaret. I don't know.
Okay.
But I filed a second amended notice of hearing. Can I give
Please.
you my copy?
And Mr. J, have you seen that, sir?
State doesn't really have a dog in the fight with the expert witness.
Understood, thank you.
Judge, what I had done
Don't
was
see
I
a date
had,
on here, Counselor. When was this sent? The certificate of services contains no date.
Uh-oh.
it was filed this afternoon,
Okay.
this morning.
Okay. And related to cost, sir.
Well, there's one for the appointment of the forensic psychologist, Dr. Julie Harper, and it's non-pro-tunc. I'd like it to be retroactive to when I actually had to hire them. As you know, I came on the case late, August, I believe, August the 30th.
That's correct.
And then I asked Dr. Harper to go down and see Sarah Boone. She lives, Dr. Harper lives in Okaloosa County, and she came down to Orange County, I believe, the Thursday after we had the hearing on September the 3rd. I believe that's when the court denied my motion to continue. And so, as you know, we had to file the notice of intent to rely on battered spouse syndrome within 30 days prior to trial, which would have been that Saturday, I believe. So she went down, Dr. Harper went down and saw Sarah again. As you know, Dr. Harper had seen her several times early on in the case, back in 2020, maybe 2021. And so she had the most knowledge of, I believe, any of the experts that have evaluated Sarah Boone over the course of these 4.5 years. She was the one expert that had seen her the most. I asked her to go down again in the hopes that the court would appoint her.
And my question is, why didn't Dr. Julie Harper say that Sarah Boone qualified for battered wife syndrome back then? Because I don't think she did.
And she agreed. That was, I think, on a Thursday. She called me that morning, Friday morning, and said, yes, I do believe that she suffered from battered spouse syndrome at the time of this offense. Based on that, I filed the motion. But so she jumped ahead and did some work prematurely before she had been appointed. So I'm asking for those costs for her to do the earlier work, that be considered, as well as Dr. Berkland. Dr. Michael Berkland is a crime scene reconstructionist and death investigator, and I'm asking for the court to consider paying for his fees as well as his transportation costs, as I have for Dr. Harper, again, to be retroactively to the time I asked him to begin work on the case. And then the last...
When was that, you're asking non-pro-tunc to win on that? Also to the August 30th date of your
Yes.
notice of appearance?
If possible, yes. That's when I officially got on the case.
Now, as to the third motion for cost, I don't have a copy of that, unfortunately. Yes, please.
Judge, I mentioned this expert, Dr. Michael Brannon, in that hearing that I think we had on September the 3rd. He's a clinical psychologist. If you'll recall, I'd mentioned him. He had served as an expert in the Marsha Thompson Palm Beach County case.
I recall.
And so...
Oh, wait, they were able to get him? I thought he was considered a forensic psychologist. Oh, so she was able to get the expert from the Marsha Thompson case. Okay.
As you know, he serves a different role as a clinical psychologist. Dr. Harper is serving as a forensic psychologist.
Hey, you said he was going to be a forensic psychologist because you said you wanted two forensic psychologists on the case.
And
Do you know what JACS's opinion with regard to the motion to appoint clinical psychologist? Because the email that you attach as Exhibit A to that appears to be Mr. Lake's email regarding the other two motions regarding Dr. Harper and Dr. Berkland, and it doesn't address Dr. Brannon, and notably JACS isn't here.
I don't have an answer for that. Maybe we could table this.
I think the state has, I'm assuming, no dog in this fight, similarly as they had with the other two.
The only request in this area that the state is going to make of the court is to, under its discretion under 3220, order these experts to produce written reports. We are on the eve of trial. I do not need one from Dr. Julie Harper. Her deposition is set October 1st. These two other people, I have absolutely no idea what they are going to say. And we would, I'll file a written motion and a proposed order and send it to opposing counsel. But that's what the state's request is going to be on the other two experts.
Yeah, I don't know if I'm going to have an objection to a written report.
I don't know if you can hear him, but is that Mr. Cacciatore? I could have sworn Mr. Cacciatore was a lot younger. The one that was wearing the trench coat. Maybe that's Cacciatore. He said that, he doesn't object, but he just wants to make sure they get like a written report.
Not, I may, but I'd like to see what the motion says
Sure.
before
And
I make a
I'm not-
decision. But yes, Judge, we have scheduled Dr. Julie Harper's deposition at her office in Okaloosa County on Tuesday, October the 1st at 10:30 a.m. Eastern Standard Time.
Is that in person or is that virtual?
No way. Wait, Sarah Bridget, do you have a link to that? Also, that Brandon expert was on Court TV. He said originally on Court TV that he didn't see it as being battered spouse. Can you send me the link to that? I don't know if you're in our Discord. If you are, can you link it in there? Or just give me the YouTube title and I will just look it up.
Is that in person or is that virtual?
I believe it.
Okay.
The state's flying in, and I'm going to be their judge. That's the county over from me, Santa Rosa County, so about an hour drive from me, so I'll be there in person. We're going to have probably Kevin Beck that's going to appear by Zoom.
All right, so here's what we're going to do. JACS has provided their response, and their response was not appended to the motions that were filed because that was prior to the amended motion seeking indigence costs that you filed, Counselor, on behalf of Ms. Boone. I'm going to hand file with the court now the September 9th correspondence from JACS reflecting that that can be utilized in lieu of a formal response. I'm going to grant your motion to appoint a forensic psychologist dated September 2, 2024, non-protunct those costs to August 30, 2024. And with regard to the other motion, the motion to appoint crime scene reconstructionist and death investigator, I will also grant that and appoint Dr. Michael Berglund, non-protunct, to August 30, 2024. With regard to the motion to appoint clinical psychologist, when was this motion filed? Similarly, the certificate of service does not reflect a date.
Pretty recent. Clinical psychologist one was filed, was it yesterday? Clinical psychologist. I think it was like yesterday. Jesus.
Let us check real quick.
Sure.
Give me a minute.
Yeah, you're good.
Well, I mean, it was in the court system yesterday, but.
Excuse me. No, Dr. Michael Brandt. It had to be filed.
While you're waiting on that, I do see on your second amended notice of hearing, you also requested the amended motion for declaration of indigency and payments of due process costs also be heard. When was that motion filed as well, Mr. Owens?
It was filed just prior to filing these amended ones.
Were the-
It had to be filed prior to my motions for appointment of these experts.
Give me a second.
I don't want
So
to.
the motion to appoint the clinical psychologist regarding Dr. Brannon, was filed yesterday. The amended motions regarding Dr. Berglund, an amended motion regarding Dr. Harper were filed yesterday, as was the amended motion for declaration of indigency and payment of due process costs. That motion has not yet been granted. It is going to be. So the amended motion for declaration of indigency and payment of due process costs is granted. The amended motions regarding Dr. Berglund and Dr. Harper are also granted, non-protunct to August 30. With regard to the motion to appoint clinical psychologist filed 9/18, I'm going to ask Ms. Barrios, my judicial assistant, to forward that directly to Mr. Lake. And I know that she's watching this virtually. If she's able to do that now, I would greatly appreciate it, and see if we can get his response to that this afternoon, and maybe we'll be able to address that. It may be a similar vein as to the prior response that JACS had provided. Moving now to the motion for return of property, or in the alternative, motion for independent exam by the defense, filed
So this is where her team wants to get the cell phone back.
September 18th. Similarly, with everything else, I've reviewed that and the authority, and I have reviewed the state's response to defendant's motion for return of property, or in the alternative, motion for independent exam by the defense. Mr. Owens, you may proceed, sir.
Judge, I believe the state's response is well taken, and I believe that what we need to do is get an expert of our own that can do the phone extraction and meet with the state attorney and the sheriff's department and extract the data, all the data that we need from her phone. So we would submit that the property should not be, based on the authority the state attorney has decided, the property should not be returned to the defendant since trial is still pending. But in the alternative, we're asking for an independent exam by the defense.
Response, if any?
As the state has stated in open court while she was pro se, that is absolutely fine. And I've even suggested a name.
Has the defense ever performed an evaluation of the phone? And the reason I ask this is there were prior experts that were appointed in the realm of electronic evidence.
Mr. Cacciatore may have the answer to that question. I don't.
Okay, so that isn't Mr. Cacciatore. Okay, Mr. Cacciatore is a trench coat guy. Okay.
But I know that the state, as I stated in my response, we've never prevented anybody from doing that. And as the homicide supervisor, everybody in the unit knows how to go about doing this and allowing a digital forensics examiner hired by a defendant to go and work with the law enforcement team and get another imaging if they are not satisfied with the imaging that has been provided.
Mr. Cacciatore, good afternoon, sir. Can you hear us? And if you can you announce your presence for the record, please?
Mr. Cacciatore?
There has not previously been a forensic exam of that phone by a previous defense counsel.
Okay. All right. Thank you very much, sir.
Why did anyone examine the phone previously? Like, why did they hire an expert to examine the phone?
There was a John Sawicki that was appointed authorized back in 2020 as to electronic evidence. So I'm going to deny the
And
motion for
Grant and
return of
Barth?
property based on the citations contained in the state's response. And I'll leave it up to you, Mr. Owens, to do what you need to do in order to have that review.
All right, I'm gonna do my best. We got about 18 days.
Who are everyone? Okay, so the two women that are sitting with James Owens and Sarah Boone, that's his assistants.
I'll cite to the parties for their own benefit. There were motions, specifically defendant's motion to appoint an electronic evidence expert and order the Justice Administrative Commission to pay costs. It was filed back on May 5, 2020. An amended motion was filed the next day, May 6th. Both of those cite to or refer to John Sawicki, S-A-W-I-C-K-I, electronic evidence expert. And there was a order entered back on August 3, 2020, appointing Mr. Sawicki as a forensic specialist.
I can't wait till we get to the battered wife syndrome.
I have no
motion.
idea if that order is still viable, but I'm just providing what the court file reflects in that regard. Lastly, that takes us to the notice of intent to rely on the defense of battered spouse syndrome. The original notice was filed September 6th. The state's original motion to strike was filed September 9.
Just to interrupt, I also have this defendant's motion for enlargement of time to address as well.
Yeah, I have that on my list, sir.
Okay.
Thank you. Thereafter, on the 15th, an amended notice of intent to rely on the defense of battered spouse syndrome was filed. On September 13th, the defense's response to the state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome was filed. And then I think it was this afternoon. Earlier today, the state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome was filed. The court has reviewed those and all of the citations contained therein. Mr. Owens, you may proceed, sir.
Judge, I wanted to start my argument, and then Mr. Henderson, who is on the screen, is going to respond to the state's pleading that they filed this afternoon.
Mr. Henderson is his co-counsel.
Mr. J, you have any problem with that?
I know there's a rule in the circuit about one witness per one attorney. I don't know what the administrative rule says about arguments, so I leave it to the discretion of the court.
Okay.
He's arguing that one motion that they filed this afternoon, that I've been working on these. He was working on that motion, so it's a separate motion.
The motion to strike.
The last motion whatever motion they filed today, Mr. Henderson, Tony Henderson here in the screen wants to respond to that. I'm going to respond to the ones that were filed prior to today.
All right, I'll allow it. All right, go ahead, sir.
Judge, as you know, I filed my notice of appearance on August the 30th.
Yes, Sarah, thank you. Or what? Do you know how long ago that was?
30th, I think 38 days prior to trial, knowing that the court had already made a ruling that you would not grant a continuance unless there was some type of exceptional circumstance. And Sarah Boone hiring or retaining or somebody pro bono coming on the case and representing her did not constitute exceptional circumstance. And so, as you know, we had the hearing after I'd filed the notice on August 30th. We had the hearing on September 3rd on my motion to continue. The court denied it. At that time, I explained to the court that I believed, after my meetings, I think I'd had 4 with Ms. Boone, that she met the criteria for battered woman syndrome, but that I needed an expert, and we were vetting several experts at the time, 4 or 5 that we were vetting, and we needed more time to essentially pick somebody to go out and do an evaluation and assessment of Ms. Boone to determine whether or not they would give an opinion that she suffered from that. Because, and I understand, the court denied our motion, so that left us with, we still had to give notice to the state attorney 30 days prior to trial of October 7, which I believe was going to be September 7, which fell on a weekend, which was that Saturday, I believe. So we got out of the hearing, I think the hearing was on a Tuesday. We had 4 or 5 days to file this notice, to timely file the notice. So looking at the file, I realized that Dr. Harper had the most time with Sarah Boone. Early on in the case, I think when Mr. Padilla was handling the case, she was appointed by the court to do an assessment and evaluation. And so I reached out to her, and she agreed to come down a couple of days after we had that hearing, and she met with and assessed Ms. Boone. I've retrieved all the notes, the prior notes, and then the notes from that meeting. And then on Friday, I spoke with her, that Friday, which I believe was the date that I filed this notice, September the 6th. That Friday,
Why do we need the timeline for everything? Do we need the timeline? Is the timeline relevant?
I spoke with her on the phone
Okay.
and immediately went down and filed the notice of intent to rely on the defense of battered spouse syndrome. We made allegations that Dr. Harper had formed the opinion that at the time of this offense, that Sarah Boone was suffering from battered spouse syndrome. And at that time, we gave the name of Dr. Julie Harper and her address where she could be found and located. And of course, the state has set her deposition for October 1. Now, the state has filed a motion to strike the notice of intent, alleging that we didn't give sufficient facts or evidence. But Judge realized at the time, I was simply trying to get it filed because the last day was the next day, Saturday. And of course, I had just gotten discovery. Judge Creighton, we have not finished reviewing all the discovery in this case. I pretty much shut my law practice down to try to do it. I've gotten my staff, and we're trying diligently to go through all the discovery. At the same time, we realize that we've got to establish corroboration of the battered spouse syndrome from eyewitnesses, from medical records, from potentially neighbors, court records, her phone and the information on her phone. So we're diligently trying, number one, to review all the discovery, which still has not been done, at the same time trying to locate additional evidence that we could utilize in helping to establish the battered spouse syndrome. In addition, the state attorney yesterday filed a notice that they're amending their discovery, and all the jail phone calls, or I think they have the ability not only to call, but they have a tablet and they can text back and forth with third parties, that they have disclosed that they have, I guess, 4.5 years worth of communications between Sarah Boone and parties on the outside, and that some of that may be relevant to the case. And we were advised that when I got in town that I was to bring a CD, and I did this morning. I went to the state attorney's office and spoke with the secretary and explained to her that here's my CD, I'll wait. And I was willing to wait in the lobby to get this additional discovery when we have 19 days for trial. She told me that there was a lot, quite a bit of it, that she would try to get it to me after the hearing, or by the time of the hearing. I said, okay. I left the CD. I told her she had my number. She could text me. I was staying at the Hilton across the street from the courthouse. As soon as she had it, I wanted it as soon as possible. A short time later, they have started, I guess, going through that material, and now they're sending discovery through email. I assume instead of the CD, they're going to do it that way. But we are receiving it. But just the volume of discovery that we have to begin with, we haven't gone through. The evidence we're trying to gather to corroborate our defense, and then additional discovery that we were noticed about yesterday.
Hey, guys, I think Mr. Owens just needs to vent. He just needs someone to vent to.
I didn't have time. I knew this had to be filed. I had one more day. As soon as Dr. Harper told me on that Friday, I knew I had until Saturday. I filed it. The state knew. They've had it 4.5 years. They prosecuted the victim in this case, George Torres, at least 3 times. I think there's more like 4 or 5 times. But they opened up a file. They prosecuted him here in this county for battery and violating the conditions of bond relating to staying away from Sarah Boone. But battery on Sarah Boone. They, if anybody, was well aware that there was a potential problem with the habitual nature in which Mr. Torres beat on my client. In addition, my client expressed in the interrogation, which I know the court hasn't seen, please look at the videotape. Please look at my phone. Please look at the videotapes. Please look at the photographs. I need my phone to show you. He comes at me. It was ignored. They've had all this evidence. They had to be on notice that this was a potential issue. And the reason being is all the lawyers that have been through this have appointed different forensic psychologists to assess her. The prosecutor that's not here today, that was here on September 3rd, when I mentioned the problems that we were going to have, getting an expert this quickly to form an opinion, said, oh, no, Judge, we're not prejudiced. We've already got an expert. We intend to rebut any said opinion by an expert that she suffers from a battered spouse. We're ready to go. We've got our expert. Such that they said, we don't even need a continuance. If, in fact, he finds somebody and they file something, a notice of intent to rely on battered women syndrome, within the time limits, we're ready to go. We don't need to continue it. We'll have our expert. And as you know, they're requesting that their expert now be allowed to go to the Orange County Jail and assess Ms. Boone, which they have every right to do, since we have filed this notice. But they indicated they would not be prejudiced. They indicated they were on notice. They didn't think it was going to happen 4.5 years, but it did. They knew all the prior abuse.
So now he's pissed because when he put in the notice of intent to rely on the battered wife syndrome, the state's like, actually, you know what? We don't agree. We're gonna try to get this motion denied. I think he's super pissed about that.
Sarah Boone suffered at the hands of Mr. Torres. I did the best I could, Judge. I filed it. I felt like I had to have an expert. I explained in general terms that she was psychologically and physically abused by Mr. Torres repeatedly over a period of time that led to this event. They filed their objections, which we believe is misplaced. The court, as you know, by that rule, let me find it.
Take your time.
Rely on it. It was prepared to respond. It's apparent not only that the state was on notice, that we were going to rely on it, it was prepared to respond and was not prejudiced in any way. The notice of intent to rely on the defense of battered spouse syndrome comports with the requirements outlined in 3.201, given the current circumstances of the case. And as you know from that rule, it says the notice shall contain a statement of particulars showing the nature of the defense the defendant expects to prove and the names and addresses of the witnesses by whom the defendant expects to show battered spouse syndrome.
There we go, statement of particulars.
Insofar as possible. Insofar as possible. I did the best I could, Judge. In addition, as soon as we started going through the discovery and gathering information about the prior events, the prior arrest of Mr. Torres, the prior prosecutions of Mr. Torres, we immediately amended the notice on September the 15th of intent to rely on the defense of battered spouse. And again, listed as many witnesses as we could based on the good faith belief that we had that corroborated either by witness testimony or physical evidence, photographs, videotapes, medical record, whatever we could find that would corroborate our defense. In addition, we've listed the ex-husband, Brian Boone, and the last paragraph, paragraph 14, says the defendant's investigation of evidence to support the defense of battered women syndrome is ongoing. The defense anticipates additional witnesses, photographs, videotape, medical records, court records, and other evidence gathered from the defendant's phone will be forthcoming. This evidence will be disclosed as it is discovered. Thank you.
He sounds like Sarah. I'm doing my best. I think that's more like a Elaine Bruderhoff thing. I'm trying. I'm doing my best, Your Honor.
Sponsor.
All right. That was a long rant.
The state is not surprised by any of the evidence that has been in the discovery for years. I'm not going to belabor the facts in the discovery, but suffice it to say that the decedent and the defendant had a violent relationship, and generally this violence seems to be fueled by alcohol. We're completely aware of all of this domestic violence history, but that does not make a battered spouse syndrome defense any more than being mentally ill without showing more makes for an insanity defense. Their original notice was insufficient, and there's no reason to argue it since they've amended it. So turning to the amended notice, it still does not set forth what they are going to show that shows that she suffered from battered spouse syndrome. Was the decedent isolating her from her family and friends? Was he telling her that if she ever leaves him, he'll kill her? We have these instances of violence between the two of them, and when we get referred to the ex-husband, Brian Boone's deposition and statement, what he reports is that Sarah Boone would attack him, scratch him, punch him, and that she was a habitual alcoholic. And he would have to lay hands on her to restrain her. So we are going to potentially dive into all of this information in trial, but there are still the rules of evidence. And the cornerstone for the battered spouse syndrome defense, which is a misnomer under the case law, because self-defense is defense, and battered spouse syndrome evidence is relevant to help a jury understand why it's objectively reasonable for a battered spouse to stay in a situation that puts them in fear of continued violence. The state, and wherein our confusion lies, is nowhere in any of the witnesses or any of the discovery that they have listed, exhibits that they don't even have been listed, medical records and so on and so forth. Nowhere does it set forth this cornerstone that is absolutely necessary before we get into any of this battered spouse syndrome evidence, before we get into any potential reputation for violence evidence of the victim, before we get into any potential specific acts of violence by the victim, before we get into the rebuttal evidence that is going to be offered against her for her violent nature and her drinking. The cornerstone is self-defense. Her statement to the police is not one of self-defense, it is one of accident. She repeatedly says there was no violence that day. So that is where the state's position is, that their notice is deficient. It only sets forth that there has been violence between the two of them, and it's apparently exclusively alcohol-related. But it doesn't go on to say this violence has caused her to suffer from the syndrome, and here's why. She was afraid to go meet with her family. She was afraid to leave. She was any of the things that make up what is actually battered spouse syndrome. And moreover, it doesn't set forth the self-defense claim, which is the cornerstone of this. None of this comes in without a claim of self-defense. And so that's in part why we filed our motion in limine with that response, is the court can and should not allow any mention of battered spouse syndrome come in until self-defense has been established at trial. And as far as I can tell, the only person that can set forth a self-defense claim, since it was just her and the decedent in the apartment that night, is her. So she'll need to testify, and then she'll be impeached unless there's a ruling that the statements that she made to the Orange County Sheriff's Office are not only a violation of Miranda, but are involuntary and unavailable for impeachment use. That's what we're hoping to avoid, because we can't unring the bell during trial. If they put on all this testimony and evidence about battered spouse syndrome and about the past violence, and then we introduce evidence about her past violence against him and against Mr. Boone, it's hard to unring that bell. And even though King versus State, a 2000, I forget which year, 19 case, allows the state to point out the things that are promised in a defendant's opening statement but then don't come to fruition, that doesn't unring the bell. So that's what we're asking for. We're asking for sufficient notice. The statement of particulars that is required by the rule, where is it setting forth there is a self-defense claim, and then there is going to be this shown beyond just the past violence between the two of them? Thank you.
Judge, they're scheduled to take the deposition of Dr. Harper October 1, so they're going to know fairly quickly what her opinion is.
What's your response to Wagner?
We're going to talk about Wagner, Judge, and I don't want to talk about that in a minute, but he's bleeding the argument into state's motion to strike the defendant's amended notice, and I would like for Mr. Henderson to respond to what he said about that. But Judge.
Because I agree, there's two different issues here. The first issue is the sufficiency of the notice, and whether the notice is sufficient under the rule. The second issue from the court's perspective, is it applicable? And that's the hang-up that I'm having.
That's not to be decided today. That's not, Wagner, whether it's an accident or whether it's battered spouse and there was self-defense, that's not to be addressed today or not to be decided today. That's going to be based on the testimony from Ms. Boone about what was going on. But I'd like Mr. Henderson, if you don't,
But that's not what Wagner stands for. Wagner didn't allow, Wagner struck after multiple amendments, and the court, and we can take judicial notice of it if you want to, the court has pulled the file from the trial court in Wagner and has looked at the notices that were filed in that case for the battered spouse defense.
Judge, ultimately, the female defendant in that case claimed that the firearm discharged accidentally.
Correct.
And the court ruled, hey, you can't have it both ways. It can't be an accident and at the same time be intentional that you committed as self-defense because you're a battered spouse.
Wait, doesn't that just go against what he's trying to do? Or because Sarah Boone said it was an accident, but at the same time they're trying to claim battered spouse. Isn't that it right there? What?
Accident, and at the same time be intentional that you committed as self-defense because you're a battered spouse.
Right. So how is battered, even
It's
taking-
premature for them to be arguing the question of intent.
But that's not what Wagner says. What Wagner specifically
specifically?
says, although the trial court found the third
No. No.
legally sufficient, the
Wait.
court granted.
What happened? Hold on. I'm going to go back.
Specifically
What specifically?
says, although the trial court found the third
No.
legally sufficient, the court granted the state's motion to strike the notice and precluded appellant from presenting the battered spouse syndrome evidence at trial. And the DCA says that the evidence underlying in that case was all accident. Specifically, the
Oh, no. Come on, Court TV. Oh, every law crime. Law crime, no.
battered spouse syndrome as admissible where the defendant claims accident rather than self-defense.
We're not claiming accident.
Well, then
But Sarah Boone said accident in her interrogation, though. Uh-oh. I wonder if Sarah Boone and James Owens, if they're going to have like a little mini row after this.
what are you claiming?
Self-defense.
But every case that you cite, Medina, Hickman, its progeny, all pertain to some act by the accused. And that battered spouse is an excuse, a justification, an explanation for those actions. How is your purported defense applicable legally?
That's the reason we asked for the statement of particulars, Judge, so we could find out exactly what they were claiming that she did, what overt act or what omission. The overt act, was it zipping him into the suitcase?
But
Was that the overt
But
act
all of the
that caused the
but
death?
all of the battered spouse syndrome cases talk about a defensive issue, not meaning defense your side of the ledger issue. I mean an action in defense. Wagner fired the gun; it was accidental. Hickman fired a gun. There was an act that was done by the victim or by the defendant in those cases, and battered spouse was used as an explanation for why it is that they did. How is that applicable to the case at
I
bar?
assume they're going to say she overtly zipped him up in the suitcase.
Okay.
I assume they're going to say
She beat him up.
he was asking to be let out of the suitcase, and she refused. She failed in a duty to act. Later on, she went upstairs and fell asleep. So it's either an act or an omission, but they're claiming an act or a series of acts led to the death of Mr. Torres, which they have alleged was directly caused by Sarah Boone's actions or non-actions.
Man, the state, they are just chilling. Oh, no, don't be zooming in on the back of her
Hickman?
head.
The defendant stabbed the victim to death. And the justification was battered spouse. In Terry, which you provided to the court, Terry v. State, 467 Southern 2nd, 761, it was firearm. What's the,
Mechanism?
what is it?
They're the only ones that can answer that, Judge. That's why we asked for the
I
statement
don't
of particulars.
understand that circular logic. And the reason I don't is because it's your defense.
Okay. I'm assuming that they're claiming that she zipped him up in the suitcase.
No, please don't repeat yourself again and again. That does nothing unless he's going to add some value to it. Okay, maybe he'll add value. I'm sorry, I'm getting ahead of myself.
Against his will, would not let him out of the suitcase, and therefore he suffocated. So the act of zipping him up and then the non-action of not letting him out when he asked to be
He's
let
repeating
out
himself.
constituted the offense of
He's repeating
second-degree
himself.
murder. That's the only explanation that we can come up with based on the report, based on the evidence we have.
But what's your defense? What are you guys saying happened? What is your side of the story?
Judge, you remember Marsha Thompson, the Palm Beach County case?
But there was a firearm.
There was a firearm.
She discharged a firearm.
Remember Dr. Brannon said, on the issue of imminent threat, it is in the mind of the battered spouse woman.
Right there's the words. Imminent threat.
That's correct.
There was a threat. Now, I don't know all the cases. I don't know the facts and circumstances of that West Palm Beach case. I don't. I know snippets that you provided to me, but I haven't read any opinions on it. I don't know where it is on the DCA or appellate perspective, and trial court findings are not binding on another trial court. I mean, the case law is very, very clear on that.
Judge, the state doesn't know what happened the 2 minutes prior, or the minutes leading up to, the time leading up to the 2-minute video. The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that. That's for her to testify to.
Because it sounds like to me he's saying that like, the reason why he wants a statement in particular is because he wants to know exactly what the state is going to say happened, and then based on that, they're going to form a defense theory against it. Well, I mean, what is your defense right now? Like, what are you guys going to say happened? And James Owens is like, well, we don't know because Sarah Boone hasn't testified yet. We don't know what she's going to go up there and say. I mean, what's her opening statement going to look like?
Florida, the appellant has not cited, nor is our research located, any Florida case holding that evidence of battered spouse syndrome is admissible where the defendant claims accident rather than self-defense.
Who claims accident?
Are you claiming self-defense?
Yes.
Well, that's the first time that I've heard that.
Judge, I just mentioned it a while ago.
The word self-defense never came out of your mouth.
Judge.
Words that you believe that the state's position is, what you believe that they're going to try to establish, that we don't know what happened before and after that video. The words self-defense have never been uttered this afternoon.
Judge, for the record, we're claiming self-defense. We're utilizing the battered spouse syndrome in conjunction with that defense.
Okay. All right.
Not accident, as they want to allege.
But then that's going to be impeached by Sarah Boone's interrogation video where she said it was an accident, the body cam footage.
Okay. Does your compatriot want to provide response further? Okay.
Poor Henderson.
Mr. Henderson, good afternoon, sir. Can you hear us?
Mr. Henderson's like, I don't want to be in this anymore. Get me out of here.
Hear me, sir. You need to unmute yourself.
Can you hear me now?
I can, but I have some concerns because I'm getting reverb. You.
Okay. Maybe they'll get through this bad internet connection. Oh God, it sounds so bad. Oh God, I'm sorry guys, it's gonna sound really bad. I'm putting the audio back up. Get ready.
And first, where I want to start is here. But just the self-defense, justifiable use of deadly force, justifiable use of non-deadly force. Those are defenses that do not require a notice at all. A defendant doesn't have to come in before trial and say that I am relying on self-defense. The standard is it's in the standard jury instructions, and before you can give that jury instruction, you have to have, and the cases are pretty clear, an indication or evidence. It's just a scintilla of evidence. That's what the cases say.
I feel so bad. The audio is so bad. I can't understand what he's saying. I mean, maybe the judge can.
To get the instruction. There's no notice requirement in self-defense at all. Now, battered wife syndrome is not a defense in and of itself. There's no such thing as a defense there. It is a part of a jury instruction, and the part of the jury instruction and what it explains is when you get to the point when you're starting to talk about imminent danger, and that because of this syndrome, they would perceive an imminent danger different than someone else. Because what the
something about jury instructions, something about the defendant perceiving this as imminent danger.
Defense instruction required is that the jury place themselves in the position of the defendant. in those circumstances at that point. Battered spouse goes to help explain those circumstances. So the first instruction that you have to get before you can even start talking about battered spouse is this. You have to get the self-defense instruction. So, and that will be decided based on the evidence at trial. The defendant doesn't have to come in and say, I am claiming self-defense. This is self-defense. There's no rule or circumstance to that extent. But there has to be testimony of self-defense. Now, once there's testimony of self-defense,
Is he supposed to be having all this in the background? We got like the list of names of people that are in jail or something. What is this in the background?
part of it, then the court can give that
And is that phone numbers? What is back here?
instruction. If they find it sufficient, the testimony can give that instruction as to self-defense. Where battered spouse comes in and it goes into a series, you have to have self-defense or some type of evidence of abuse before you can get into the battered spouse. And this is how it should work. There could be the testimony of Ms. Boone. There could be testimony that's actually in the notice from officers who responded to calls and actually observed physical injuries on Ms. Boone. There could be testimony from others, neighbors, or other people who observed injuries or certain things to Ms. Boone. But once you get to the point where you significantly or sufficiently apply that there is a battery or domestic violence situation that is ongoing, then, and not
The closed captionings gave up. It stopped popping up.
can the expert come in and testify. So the stopgaps on this that are built into our system. First, there has to be some accountability or some evidence of self-defense. Secondly, there has to be some evidence that will support the expert's testimony to become relevant at that time. Once the expert's testimony becomes relevant, then the expert can testify about these are the symptoms that I observed, this is what I watched, this is where it came from, this was interviews, this was reviewing other type of data and other types of things and preparing their expert opinion. So after that point, Judge, when you get to that point, then it doesn't become a judicial act at that point in time. What it becomes a jury question. And it is up to the jury to decide. And what it does, and it doesn't say that battered spouse is a defense. What it will talk about, and the jury
I'm sorry, I kind of gave up listening because it hurts my ear. I don't know what he's saying.
instruction is, this is something in the back and will report. Under these circumstances, if you find it credible, that you can consider. And that's what it does. So we at the beginning, when we started talking about motions to strike, because if I think the case was Wagner, there wasn't any testimony there. Wagner's testimony was excellent in that case.
Something about Wagner's testimony.
And I really put it. No one reviewed the ruling of that. That was the testimony. In this case, we do not have testimony. What we have is to say in this case, saying the discovery in this case showed it. But that's not all. These rulings have to be made better on the testimony of critical report, either testimony itself,
Mr. Henderson,
Yeah, it's kind of like the peanut scrotum speech. I feel so bad for him. I feel bad for him. It sucks when you have shitty audio.
we're having a difficult time understanding you, sir.
I'm sorry, Judge. Is that better?
No.
Maybe. Madam Court Reporter and I were having a little bit of difficulty hearing you at the end. You seem to be projecting away from where your microphone is.
Okay.
First of all, he needs to go into a room that's not this echoey. He needs to speak into a microphone, not out into a room. Ay, ay, ay. Someone help him.
Can you hear me better now?
I think the judge and the stenographer can probably hear him way better than we can, because we're probably just hearing the echoes within the courtroom. They're getting the direct feed from him.
Madam Court Reporter.
Poor Madam Court Reporter.
We will do our best, sir. Keep going.
Yeah, so to bring it in for a landing, Judge, is simply this. And to the court, here's the evidence that permitted at trial. The court cannot make certain decisions. The court can't make a decision if justifiable use of non-deadly or justifiable use of deadly force is appropriate to give, and to the evidence at trial. At that point in time, the court has to make a decision if, after evidence, if the expert's testimony is even relevant. So if there isn't any testimony to prove the relevancy or to show the relevancy of the expert's testimony, then that expert can't come up and talk about that as spouse. Now, if you don't get the expert to talk about that as spouse,
What's going on with the camera?
and render an expert.
It's still our position that the plea.
Okay, we couldn't hear him, so we're just gonna skip through that. Mr. J, save us. What is going on with the camera?
It sounds like we're largely on the same page. The one point that I would strongly disagree with is that this evidence of battered spouse syndrome is relevant to the subjective belief of the victim or the defendant. That is not what evidence is used for. It's used to help a jury understand what an objectively reasonable person would do in those circumstances. And there's more cases that I have not cited because I didn't know that would be raised today, but they kicked out PTSD testimony just last year, I believe it's an Okendo, because it was going to the subjective beliefs of the defendant rather than helping the jury understand why an objectively reasonable person in a battered spouse syndrome would stay. But that notwithstanding, it appears we're on the same page, that the jury should not be hearing anything about battered spouse until the predicates are laid. And from the state's position, to help us prepare for trial, pleading should be sufficient. And it's still our position that the pleading was insufficient. The state is well aware of the past violence between the two of them, with her being the aggressor and the decedent being the aggressor. There's evidence of that all throughout the discovery. But what isn't present anywhere in the discovery, and what left the state at a lapse in understanding this defense in particular, was, did this violence cause her to suffer from battered spouse syndrome, and what is this evidence going to be? Was he isolating her? Was he keeping her away from family and friends? Was he psychologically breaking her down? Was he doing any of these things that are a component of the battered spouse syndrome? Because all we have is her statements, which are almost 100 pages long, to the sheriff's office, where she repeatedly says that night that nobody laid hands on one another. It was a great night. We were hanging out, drinking wine, doing puzzles, painting, dancing with the dog.
Don't forget about playing hide and go seek.
And then, like everybody else, we were playing hide and seek.
Oh, there we go.
And he got into the suitcase, and I accidentally went to sleep. And then she's shown her video. But her statements are all that it's an accident and that there was never any claim of violence that day between the two of them. So that's wherein the state's confusion lies. And I don't know how we're going to go about this at trial, if the defendant's going to have to testify in a narrative form, if she's going to come in and testify 100% differently than how she gave statements to law enforcement. But that's where we're at, is we don't want this in front of the jury until all of the requirements are met. And as far as I know, the only person that can say that it was a justifiable use of force that night is her, because it was only her and the decedent in the home that night. And thus far, she has...
Do you think, oh, I guess we didn't see that, but they had a list of witnesses that were going to help, I guess, with their battered wife syndrome, and the ex-husband was listed on there, and then a bunch of other law enforcement officers are listed on there. But I don't see anyone that's another Sarah Boone family member, like brother or anything like that.
has not made any statements about a justifiable use of force. And then our second complaint about the intent to rely on the syndrome, again, without repeating myself, is it just sets forth that there was past violence between the two of them, but no particulars about what actually makes up the rest of the syndrome. Thank you.
Okay, so that makes sense. He's saying that they had a good time. She said they were having a good time. Where's the justifiable use of force there when she said that she left him in there by accident?
Any other final
Poor judge.
positions?
The judge is like, oh, Mr. Owens, you got anything else you want to say? Look at the judge's face.
Offered in rebuttal to the state's argument, either Mr. Owens or Mr. Henderson?
Well, just, I'll let Mr. Henderson go, but just as it
No,
relates
don't let Mr. Henderson go, please don't.
to Ms. Boone's testimony, that's what jury trials are for.
Okay.
Mr. Henderson, any further arguments, sir?
Oh, shit.
You're muted. You will have to unmute yourself.
Hold on. I'm gonna turn the audio down.
Mr. Henderson, you're still muted, sir.
Mr. Henderson just needs someone to help him with this technology stuff, that's all. Mr. Henderson!
I'm sorry, can you hear me now?
Loud and clear, sir. Any other additional argument in rebuttal?
Yes, Judge. The state is going to have the opportunity to depose the expert, Ms. Harper, who can tie those things together. That's why we have experts who know about these things and who have the knowledge, who can tie these things together and tell why she's of the opinion that she was suffering from battered spouse at that time. The notice is simply to require to let them know that we're seeking this avenue and here are the witnesses that we're using to seek the avenue. We don't have to list a specific number of witnesses. It's just the ones that we intend to use. And as Mr. Owens has told you, this is an ongoing process and we'll probably be adding more. But that's all I have. Thank you.
All right, thank you very much. The court is going to take the issue under advisement and provide a written order. I'll endeavor to do that by the end of the week.
Okay, written order.
Last is the defendant's motion for enlargement of time filed September 17th. Mr. Jay, have you had the opportunity to review that?
Yes, Your Honor.
Okay, all right. Any problems with proceeding with that this afternoon?
No, Your Honor.
Okay, very good. All right, I have reviewed that motion. Mr. Owens, you may proceed, sir.
Judge, and I do have about 2 or 3 other issues that we need to address, but I've asked for some time. I think there was an order, I know there was an order that you had submitted to writing and that was filed with the clerk's file that indicated that you wanted some things from the defense and from the state by certain dates, and I think that's a typo in paragraph 3. I said August 17, that should be September 17. On paragraph 3, Judge, of my defendant's motion for enlargement of time?
It says September 5 on paragraph 3.
Are you looking at my defendant's motion for enlargement of time?
Yes, sir. Paragraph 3 says Dr. Julie Harper met with defendant Sarah Boone on Thursday, September 5, 2024. Am I looking at the wrong thing?
I'm sorry, I was looking at the wrong one. If you look at the second page.
Yes, sir.
Paragraph 7.
Yes.
That should be September 17.
Yeah, got it.
Okay.
I mean, obviously, the court's order, the August 5 order speaks for itself.
Judge, and as you know, we came in late. Dr. Harper formed an opinion that week. We filed a notice of intent to rely on battered spouse. It's ongoing. That's all I can say. We're working, we're doing everything we can to uncover evidence consistent with our defense. The problem is it's 4.5 years ago, and the apartment complex in Winter Park has changed hands. So we're trying to run down the employees. We're trying to run down the other tenants of the place. We're trying to run down medical records. That office manager is critical. We've taken her deposition, but we can't find her. Brandon, I think it's Moats, the neighbor that lived right next door to Miss Boone and Mr. Torres, and they shared a wall.
Poor
Is a critical
Judge.
witness in the case. We're trying to locate him. As you know, 4.5 years, people move, so we need more time, is my point. We're doing everything we can. We're working diligently. Billy Lane, the investigator, is working diligently to try to gather the information I'm asking him to gather. Coupled with the fact that we've got this phone that we're going to be extracting, I'm in hopes of in a few days. And And I know that the state had extracted the phone and given us a lot of the data from the phone, but Ms. Boone says it's incomplete. That's the reason we want our own expert to extract it, that will be able to assist us in establishing evidence and testimony that she is a battered spouse and was a battered spouse prior to this event. But because of that, Judge, we haven't had time to complete that. And as I said in my motion for enlargement of time, we're asking to be flexible on some time limits up to and during the week of the trial, because we're going to be working that entire trial. Like I said, there's 18 days until trial starts. It's going to be a 2-week trial. I don't know when some of this information is going to come, but I assume every other day we'll probably be amending the discovery, the reciprocal discovery, and amending the notice of intent to rely on insanity or rely on battered spouse if we find other
He
evidence
almost said insanity.
that corroborates that. So we're just asking the court, and I know there's a rule that specifically, this rule 3.050, that allows for this request. Thank you.
Thank you very much. State, any response?
Certainly, the state is not going to be okay with them conducting their investigation once jeopardy has been attached. That is completely unfair to the state. This is the defendant's trial, not Mr. Owen's trial. She has been on notice of these charges since February 25th of 2020. She has gone through countless attorneys here who did not pursue this battered spouse syndrome defense, even though they had consulted with Dr. Harper back in 2020. And I believe the crux of that issue is going to revolve around her having to testify in the form of a narrative given her prior statements. So the state opposes any enlargement in time. The defendant has been on notice and has had centuries probably of legal expertise at her disposal for the last 4 years. And there may come a point in time where the state has to request a continuance prior to trial, but if this enlargement is granted. But certainly, once jeopardy is attached, that's not the time to be doing discovery. She's had 4 years to do this, 4.5. Thank you.
Any other final arguments, Mr. Owens?
No, sir.
Okay. I'm just rereading the rule. Give me a moment.
Take your time, Judge. Man,
When we
Judge.
had our hearing on September 3rd, at that point in time, the court had outlined the history of the case, the court's prior findings, the numerous experts that had been retained throughout this case, and I understand the position that you find yourselves in. But at the same token, based on the same analysis that the court had relied upon in its oral pronouncement in denying your continuance on September the 3rd, I'm going to grant your motion and deny your motion in part. With regard to the filing of objections to the state's exhibits, by your own statement, you're still in the process of going through those. The deadline expired on September 17th. So I believe that we're using the second portion of the rule with regard to that issue because there was a requirement to provide those names, and this motion was filed on the 17th. So I'm going to grant your motion in part with regard to filing objections for the state's exhibits.
And that was something the judge was already willing to do because they spoke about that the last hearing.
Give you up until the time that we're having our trial case management on September 26th to file any additional objections to any of the state's exhibits.
Oh, September 26th.
With regard, however, to the filing of a witness and exhibit list, I agree with the state. We can't be amending once jeopardy attaches to provide additional experts or any witnesses at that point in time.
You're talking about jeopardy when the jury is sworn?
Correct.
On that Monday, October 7th?
If we're lucky enough to get one on Monday.
So,
Just so that you understand, I've ordered a couple hundred people for that week because I don't know how long jury selection is going to take. I don't know what people know about this case.
Judge,
So my intention is to run 50 people in the morning. So I'm just letting you all, full disclosure here, what my thoughts are. 50 people in the morning, get rid of language, get rid of cause. And if those persons who don't know anything about this case, I'm going to ask them to come back, either Tuesday or Wednesday. And then we're going to run another 50 at 1:30. get rid of our cause challenges, those who can't be here for 2 weeks, those who've just recently given birth, all the statutory cause reasons that they can't be here. I'm going to ask them to come back. And if we've got 40 people, 50 people at the end of Monday, we'll start Tuesday, and we'll start whittling it down. And I can turn over, when I'm done with my colloquy, my voir dire is about an hour and a half, 2 hours. And then I'll turn it over to the state, and I'll turn it over to you, and we can whittle it down from there. But if it takes us more time to get a sufficient panel because of the amount of time and other causes or preconceived notions about this case that can't be set aside, we may not be picking a final jury until Wednesday in this case.
Is this set for 2 or 3 weeks?
2 weeks. 2 weeks.
Do you have a calendar?
Now, it was originally set for 3 weeks. And then when we talked about it, when you came on board, we had shrunk that to 2. Now, if we think that that may change, I'd rather discuss that now than a week from now. If you think we need 3 weeks, I can try my best to make that happen. But I respectfully...
I think this judge lost more patience for James Owens than he had with Sarah Boone. I've never seen him this heated.
We need to know that sooner rather than later.
But he's still calm. His voice is just quite elevated.
Because in all candor, I don't know how long it's going to take us to get a jury.
I did not anticipate. I anticipated we were going to be able to pick a jury in one day.
I would love to be that bullish. I hope we can. I'd love to be able to. I'm just telling you what I've been working with jury services, that I've got 50 people teed up for 9 a.m., I got 50 people teed up for 1:30, and that will continue throughout the week. It's easier for me to say, we don't need you, go home, you don't need to show up for jury service, than it is, I need bodies, and we don't have them. Now, if we're able to get a jury in one day, fabulous.
I don't know. Do you think they're going to have a jury in one day?
But if we can't, I have that backup.
I believe if we pick the jury in one day, we could try the case in 2 weeks. But if it's going to take a little bit longer, and again, we don't know from now until October 7th what other evidence or what other witnesses we're going to uncover. So in the abundance of caution, I'm going to ask the court, if possible, to set 3 weeks. I don't think it's going to take 3 weeks, but I don't know how long jury selection is going to be. I don't know what additional evidence we're going to uncover, additional witnesses from now until October 7th. So to be on the safe side, I would ask for 3.
Okay, all right. I'll see what I can do there, and I'll have Anita report back to both of you.
Judge, and the main reason, I think all these other lawyers, they didn't have an expert that had tendered that opinion about her spouse. So we started on this path
But one of the attorney had Dr. Julie Harper. What?
on that Friday when Dr. Harper called me and I filed the notice of intent to seek corroborative evidence, corroborative witnesses that she was battered. So that didn't really start until that day, which was September 6th. And that's why, and again, this was an event that occurred 4.5 years ago, trying to locate witnesses, it's just taking time. I understand about the jury being sworn and we shouldn't be allowed to ask additional witnesses to come in. So I agree with the state on that, I agree with the court, but I would ask up until the time we pick the jury that we be allowed to amend reciprocal discovery and amend our notice of intent to add additional witnesses and additional evidence.
Mr. J, any other further positions?
Hey, Hannibal, what's up? How are you doing today?
Sir.
There just may come a point in time, Judge, if you don't set a deadline, that the state has to ask for continuance.
The deadline is going to be for objections to the state's evidence, providing of a witness and exhibit list for the defense at trial case management next week, September 26th at 9 a.m., in addition to all the reasons that the court placed on the record on September 3rd during the motion to continue. My JA has advised that Mr. Lake has appeared virtually with regard to the motion to appoint clinical psychologist. Mr. Lake, can you hear me?
Oh, please, let's hope your audio is better, Mr. Lake. So Mr. Lake is part of JAC.
Yes, I can, Your Honor.
Can I get your appearance for the record, please?
Yes, Christian Lake on behalf of the Justice Administrative Commission.
All right, thank you, sir. Earlier today, before your participation, I know that Mr. Owens had provided you certain cost motions regarding the forensic psychologist, Dr. Harper, and the crime scene investigator, Dr. Birkland. You had advised as the JACS's positions on those motions. Your email has been filed in the court file. Subsequent to that, a motion to appoint clinical psychologist regarding Dr. Michael Brannon was filed. That was just filed yesterday. I know my judicial assistant sent you a copy of it. Have you had the opportunity to review that motion? And if so, what is JACS's position?
Your Honor, just briefly, we did review the motion. Although we're not contesting it beyond objecting, we do object to any rate in excess of the rates established by law, but we acknowledge for this type of expert that it would not be uncommon to approve a rate of $200 an hour. It's if that does exceed the rates established for this circuit.
Mr. Lake, I hate to interrupt you, sir. Madam Court Reporter's having a difficult time hearing you. If you could start over and slow down just a smidge for us, we would greatly appreciate it.
Not a problem, Your Honor. We did review the motion to appoint the expert. Just to give the court some background, because I went back and looked through our files. So far, the defense has incurred, this is prior to Mr. Owen's involvement, but so far the defense had previously incurred $7,500 for one mental health expert, and that's the same mental health expert that's being, not this expert, but was the other expert being requested, was requested by the defense in the other two motions. The defense also incurred $1,800 for a mental health expert that was hired by Ms. Cashman. That was, let me just get the right name, I don't want to say the wrong name, but she was paid $1,800. She was retained in relation to the issue that was before the court today, the battered spouse syndrome. And now the defense is requesting a third mental health, but also at the rate of $200 an hour. Based on the nature of the case, Your Honor, we have no real, other than objecting to the rate because it does exceed rates for the circuit, we don't have any other concerns about the appointment of the expert. It would be the third mental health expert appointed to assist the defense, but that really, I mean, ultimately that's your call whether to allow the defense to incur costs for a third mental health expert.
Okay, so he said that Sarah Boone has already incurred about $7,500 for mental health expert. I think $1,800, one that Patricia Cashman requested for. Now this would be the third mental health expert, and they object to the rates. But in terms of whether or not they can hire this new expert, he's saying, I don't know, it's up to you, the judge.
The motion reflects the rate is $200 per hour. Is that in excess of the JACS rate?
Your Honor, it's in excess of the rates for the circuit. Those were the rates that were adopted back by the old Immigrant Services Committee back in 2007. We essentially generally don't ask for a hearing unless the rate is over $200 an hour. So we generally, again, we acknowledge that is, that the rates generally range for mental health experts range between $150 to $200 an hour. So we don't particularly object to them. As far as what the rates were at that time, they are posted on our website, and I'm pulling them up right now because for the Ninth Circuit.
No, this is not an appeal. They're going to have trial next month.
The rates for medical doctors and psychologists are $160 an hour for out-of-court services and $178 an hour for in-court services.
State anything further?
Nothing on this.
Okay, all right. The court is going to grant the motion to appoint Dr. Brannon. I know that the state advised that this is not going to be non-pro-tunc because I've received nothing from you, Mr. Owens, that he's done any work yet.
That's correct.
Okay, so this will be effective as of today, the 17th of February.
September?
Yeah, is that not what I just said? I'm sorry if I did. Said a different date. I will take it under advisement the issues pertaining to the battered spouse syndrome and provide a written order. You had advised there were some other issues that you wanted to bring up, sir.
What else is there? All right, so all the experts granted.
This relates to the investigator, Billy Lane, who's working with the defense, and his potential costs up to the trial.
Are these being hand filed now?
Do I only have one account on TikTok? Mm-hmm. It's the same username as this one.
Mr. Lane handed them to me right before we came in, so I'm going to have to scan these in and file them.
Okay.
I wanted the court to be aware. If you want to address it at the September 26th case management conference, we can do it then.
Let's do that. Just do me a favor if you could, sir. Once they're filed, just forward them to Ms. Barrios.
Okay.
So that I've got hard copies of them.
All right, I'll do that.
give these back to you, sir.
Judge, the other thing was, of course, we've got trial coming up quickly, and generally, when in a courtroom, I do opening statement, I maybe have some demonstrative aids, but I walk around, and I understand here that we've got to be in front of a microphone. Is
Yeah,
there
be
any
in front of the microphone. Don't be walking around. I hate that. Oh my gosh, let us hear. Good night, Paul. Have a good one.
way we can set up, maybe the defense can set up a system where we can wear a mic so that we can walk to some degree?
I will have to check with court admin.
All right. And then the other thing is, we would like Sarah to wear street clothes. So do I need to
So
file something?
get in touch with the public defender's office. When Ms. Boone was representing herself, I had coordinated and communicated with the public defender's office multiple times in an attempt to obtain clothing. Before you came on board, Mr. Owensbury, Click, B-A-R-R-I-E-C-L-I-C-K, had provided the total amount of clothing that they had that would fit Ms. Boone, including shirts, pants, slacks, skirts. And that was the time where she would be allowed free reign and was going to have the shock device on her lower leg. I would ask that you can email Ms. Glick. You can find her information on the Florida Bar webpage, and ask her if the public defender would assist you in providing clothing. They were going to while Ms. Boone was representing herself, and I imagine that offer would still be extended.
Judge, and I anticipate 2 more pretrial hearings. 1 is the case management conference, and 2, if I file the motion to suppress the statement made during the interrogation, we would probably have to set a separate date. Can she wear street clothes at those 2 hearings?
If you can get it to her. Okay. So that's something you'll have to work with corrections. I don't know that they're going to let you do that.
Now, when it comes time to trial, she would like for us to have some makeup for her and somebody to
Apply
fix
for
her
her?
hair in a way that's presentable to the jury that she would like to be presented. Do I need to file a motion on that, or?
I think you're going to have to.
Okay. I believe that's all I have, Judge.
Okay, all right. Anything else, State, we need to address? All right, anything else, Mr. Owens, or from your co-counsel?
No, Judge.
Okay, I will see you all on September 26th at 9 o'clock in the morning, and I will endeavor to get you a ruling on the battered spouse issue as soon as practical, hopefully by tomorrow.
Thank you, Judge.
All right, thank you all very much. We're off the record.
Oh my God, Judge is like, let this be over. Oh my goodness, what a crap storm. Lots of motions denied. We will do a recap. That's a lot. It's a lot of recapping. Judge Wayne Wooden is like, oh, thank God, it's not my case no more. I don't know if she has makeup in... I don't think she has access to makeup, does she? Poor judge. I think the judge did a great job, though. All right, is that it? Is that the end of the feed? People are always like, watch till the end. I'm like, okay, fine. I think that's it, though. Someone sent her the bruise kit that Amber used. Okay, all right. Hey, Chrissy, how are you doing today? No, I do not. I have worked with an attorney before, but nothing related to like legal stuff like this. It was all like financial stuff. So makeup wouldn't hurt. Probably doesn't own any in prison, and makeup is expensive as fuck. Give her some cover, girl. All right, y'all. Let's do a little recap. Oh my God, that's a lot. Poor judge. I feel like the entire time the judge's face was just like this. Let's see. Which one do we want to freeze on? Yeah, this explains the judge almost the entire time. So, like I mentioned early in the beginning of this video, there were a lot of motions that they had to address today. And I really liked it that James Owens put it all in this one pager. So we have it as well. All right, let's start with what they did. What did they do? Defendant's motion for statement of particulars. So that one was a little bit weird for us because it seems like, the whole thing is straightforward. What happened between, like Sarah Boone and George? Now, we may not know the super specifics, but it seems like Sarah Boone left George in the suitcase. She could have unzipped him. She didn't. She's saying she was talking shit to him. And then at some point, she just left him there. And the next morning, she found him dead, right? The defense, they want a statement of particulars because they want to have the exact specifics of what the state thinks happened in order for them to build their defense, I guess. And so that's been denied. The judge was like, no, we have a date. There is a time there. We know when it happened. There's the underlying charge here. You don't need a statement of particulars, okay? So that was denied. The next one, defense motion for additional discovery and second motion for additional discovery. Oh, this was when the defense was asking for the policies and procedures of the Orange County Sheriff's Office back in 2020 when they arrested Sarah Boone. I thought it was really funny because when the state replied, they were like, well, I mean, did you even try to get it on your own before you reached out to us? And so he went up there and he was like, I did see that, we could have gotten it, but I've tried to get it. And why should I try to stay in line and get it and waste my time when the state can probably just get it in a day? And so they got into the defense saying that the interrogation was coerced, that the Miranda rights was not fully read correctly, that there was a card where law enforcement read the Miranda rights, but she omitted two of the statements or something. And the judge was like, okay, well, let's say that they didn't read the Miranda rights on the card correctly. Was Sarah Boone's constitutional right violated in any way? There's a lot of back and forth. And at this point, the judge was kind of getting a little bit, I don't want to say impatient, but sort of a little bit impatient with Mr. James Owens here. There was a lot of back and forth happening there. And the judge was like, okay, well, we're going to deny this. So that was denied. Next one. We finally get some wins for the defense. Defense motion for a forensic psychologist. He wanted to have an investigator, crime scene reconstructionist, and then the clinical psychologist. So all that was granted. So they're going to have Dr. Julie, who was the therapist that moved Sarah Boone back in 2020. She said that Sarah Boone qualifies for battered spouse syndrome. And then the investigator, who was a death investigator, death investigator / crime scene reconstructionist, that was granted. And then also the clinical psychologist that was the expert on the Marsha Thompson case, where it was a woman who shot her husband and she was acquitted for that. I don't know too much about that case, but like I said, I do want to read up on that before we go into the Sarah Boone trial. Someone in my chat, though, did mention that apparently that expert was on a court TV panel and said that maybe they looked at this case and said it didn't qualify for battered spouse, but they were going to send me the link. So I don't know if that's true or not, but I'll wait for the link to be sent, or I'll try to look it up myself if I can. Maybe it's on Reddit or something like that. There was like indigency costs that was granted. Okay, defense motion for the return of property. So this is where the defense, they want to have Sarah Boone's cell phone back. And the state was like, no, it was seized and it was done correctly. It was done legally. We're not going to give the cell phone back to you. And so it seems like Mr. James Owens, he was like, okay, all right, fine. You're right. But you know what? At least we need to have an independent examination done by our expert of that phone. And Mr. J on the state side was, well, I mean, you guys had this case. Well, not him, but Sarah Boone has had this case for 4.5 years. I don't know why no one requested it, but if you guys want to have another expert to examine it, I mean, go ahead. That's what we said from the beginning when Sarah Boone was pro se. We even suggested her an expert that she could use, which I don't know, if you're defending yourself and the state's trying to get you, on these crimes, I don't know if you want to use their experts, right? So that one was denied in terms of the state will not give the cell phone back to Sarah Boone and her attorneys, but they'll just have an expert that they'll hire to go through the phone, I guess. Next one. This is the big spicy one. Defense notice of intent to rely on battered wife syndrome. We had some Elaine moments where we had like, I'm doing my best. I'm just trying my best. I'm doing the best that I can. You know, poor Mr. James Owens. He really is trying to do his best, and he's on this time constriction here. You know, but then again, he knew what he was signing up for. This one right here, the judge said he'll have a written order by the end of the week. So I'll keep refreshing the Orange County website to see the decision on that. But there was a lot of back and forth between the judge and James Owens. And, you know, I could see the judge getting a little bit impatient with James Owens at some point in time, especially when they were citing the case. So basically what it came down to was James Owens was like talking about the cases that he cited, where it's like, oh, you can't claim accident and you can't claim battered wife syndrome at the same time. The judge is like, yeah, exactly. So what are you talking about? You're exactly saying what you're trying to do. And then when it really came down to it, James Owens was like, well, we're not claiming it was an accident. We're claiming self-defense. And the judge was like, when did you ever say that? You never said self-defense. And James Owens like, I did say self-defense. The judge is like, you have never said self-defense. Are you saying self-defense now? And James Owens like, yeah, we're saying self-defense now. But, you mean, we saw the interview with Sarah Boone. She said accident. So, you know, they're going to claim the self-defense thing, but when they go to Sarah Boone's interrogation body cam video, Sarah Boone's going to say it was an accident. So good luck with that, Mr. James Owens. So yeah, the judge is going to give his ruling on that by the end of the week. We'll see what happens. The state's response to that was, for it to be battered wife syndrome, that has to give the jury an understanding of why the person did what they did. So if I was a battered wife syndrome, I murdered my husband. The reason why I did it was because I'm a battered wife and, you know, I was in fear of my life. And at the time I thought, you know, there was a justifiable use of force because I thought I was going to die at the time. Right. And so Mr. J is saying Mr. J was saying there's no justifiable use of force because Sarah Boone kept saying that they were having a good time. They were playing puzzles. They were dancing. They were drinking. They weren't hitting each other. They weren't beating up on each other. Everything was fine. So Mr. J was like, there's no justifiable use of force. They were having a good time, per Sarah Boone. And that Sarah Boone herself said that it was an accident. So there's that. Last one is defendant's notice of enlargement of time, which I think is a really funny way to phrase that, enlargement of time. So for the enlargement of time, Mr. James Owens, the defense is like, oh, we're having such a hard time locating the witnesses. You know, this is back in 2020. We got to locate everyone, blah, 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 blah. And the state was like, well, I mean, Mr. James Owens, you're not put on trial. Sarah Boone is. And she's had 4.5 years to do all this work, and it's not our fault. And so James Owens wants to, you know, make sure that if he's going to file an exhibit list and witness list, he wants to do it like as late as he can. But what the judge and the state is saying is that, well, once you have the jury, once they're sworn in, you can't be doing that. You can't be summoning extra witnesses afterwards. So it seems like Mr. James Owens, he accepted that. The judge will allow him to object to, I think, the exhibits up until, I think, next week. They're going to have another hearing next week on the 26th. What day is that? That is exactly 1 week from now on Thursday. So they're going to give Mr. James Owens a chance another week to object to the state's witnesses or exhibits, sorry. But in terms of Mr. James Owens, the defense filing their own witness and exhibit list, you know, they can't be doing it after the jury has been sworn in. Mr. James Owens thought the jury selection was going to happen in 1 day. The judge is like, 1 day? Are you sure? I honestly don't know if it would even happen in 1 day. Because again, this has been ongoing for 4.5 years in Florida. We don't know how many other jury, you know, people who could be potential people in the jury. We don't know how many of those people know about the Sarah Boone case. So the judge is thinking, you know, maybe this will take 2 to 3 days for jury selection. James Owens was hoping it would take 1 day. But now Mr. James Owens is like, okay, well, if you think it's going to take more than 1 day, then I'm hoping maybe the trial will be like 3 weeks. So I think they're going to kind of discuss about that, whether or not the trial is going to be 3 weeks. They want Sarah Boone in street clothes. There's going to be potentially 2 other pre-trial hearings. So one is the case management for next Thursday. And then another one is going to be addressing Mr. James Owens' motion to suppress statements made by Sarah Boone in the interview, in the interrogation and stuff like that. So we'll see what happens with that. They're going to put Sarah Boone in makeup and hair. And yeah, that's a lot. That's about it for today. But they got a lot of things done. Now, is it kind of reminiscent of Sarah Boone going pro se and the day going by a lot longer because of a lot back and forth with the judge and Sarah Boone? Sort of, but I mean, these things happen, right? When you're defending your client when you're a defense attorney, there is going to be a lot of back and forth with the judge. But this back and forth seems a little bit frustrating because it seems like the judge just wants Mr. Owens to just go straight for, I think he just wants Mr. Owens to just address what he wants and go exactly for the specifics. Mr. James Owens, you know, he kind of does rant a lot, you know, and I think he just wants to make sure everything's on the record and make sure the timeline is all there so the judge fully understands. But when they were going back and forth about the case law stuff, and then when they were going back and forth about whether or not defense is trying to claim self-defense or an accident, you know, that was kind of that was a little bit painful to watch. That was very painful to watch. So that was a lot. I'm sorry, guys. If I missed any of your comments, I'm so sorry. I was just trying to recap everything right there. Oh boy. Do you guys have anything you guys want to say? So next week, we're going to have a case management 1 week from now for Sarah Boone. So I'll see you guys here next Thursday. Before next Thursday, though, I do want to watch, and I've already mentioned this, but I do want to watch, you guys said there was like some Brian Boone police interviews. I want to watch that. I want to rewatch Sarah Boone's body cam footage, which I know kind of sucks because I think the win, but I wonder if I can if I can import it into my video editor and then use like AI stuff to get rid of the wind sound. Maybe we can try that. And then also, I do want to listen to her interrogation video again, just to get like a whole refresh on everything. So we are ready for trial. Okay, ready for trial. Mama Jama, I appreciate you being here. Oh gosh, was there anything else? Okay, so in terms of like other cases, I know there's been a lot of stuff happening with P. Diddy. I do want to go over the indictment at some point, or I don't know if I'll do that on a live stream. I might just do a video about that. Because I read the complaint against him when it was filed by his ex-wife, Cassie, and it was a lot. It was a fuck ton a lot. Like there's a lot of crazy shit happening there. So I haven't read the Diddy indictment yet, but I'm assuming it's going to be even more crazy shit. Like what happened with Cassie is probably just like a small, like it's like in comparison to everything that he's done, the Cassie thing is probably so small, and there's probably other people out there, other victims and stuff like that. So I definitely want to look into the PDD stuff and the Madeline Soda stuff. There's a police interrogation video of the mom now. That case actually really makes me like super pissed off, but I do want to watch the mother's interrogation video, and I think I heard that they may give her, what's it called again? Derivative immunity. Ugh. Jen Soto interviewing with the Media Tech was amazing. God, I fucking hate Jen Soto. I fucking hate her so much, but you know, I do want to see her in the police interrogation, because from everything that I've read, and it's only been things that I've read, it's just so infuriating. I don't know how mom could just fail her daughter like that, but you know, I feel like she was just very focused on herself. But yeah, I mean, that's about it for the Sarah Boone stuff. I appreciate you guys being here. Feel free to join the Discord if you guys like. We do have a true crime section. If there's anything about this case or other cases you guys want to discuss, feel free to put it in there. I'll link the Discord. Yeah, I just want to see her reaction. Why does she want to be in plain clothes for the pre-trial? No jury, so no need. I don't know. I have no idea. Maybe to look good for the, you know, the long crime and the court TV streams. Maybe to look good for us. I don't know. I don't see what's the point. But I mean, if they want to do it, the judge is like, okay, go ahead. I don't care. Apparently, the co-counsel lost his medical license due to storing bodies. I heard about that, but I thought it wasn't the co-counsel. I thought it was an expert that they were looking to hire or something, not a co-counsel. And it was someone that lost their medical license. Yeah, I don't know. I haven't looked into that yet. Her attorney ending with a request for hair and makeup was like a really poor topic to stop with. In my opinion, no remorse, but loads of vanity. Watch the Brian Boone Carr audio interview with the detectives. That's a good one. Okay. I will definitely do that. I can't wait to read Judge Cranick's decision on the battered spouse defense. Yeah, I won't be here because I think I will be in Hawaii by then, but hopefully I can probably do like a laptop stream or video, something like that, because I do look forward to reading that. I don't know. I love it when, like, I love reading when attorneys put in their motions and stuff like that in, but when the judge makes a ruling, oh my God, I don't know, it's just something about it. Just sometimes just really satisfying. But all right, well, that's it for today. I hope you guys have a great Thursday. I hope you guys take care. Have a good one. And I mean, the judge says they're going to make their decision this week. Tomorrow's Friday, so maybe he meant by Friday. I don't know, or he didn't realize that today was Thursday and that he only has another day, but we'll definitely be refreshing. Yeah, I appreciate you guys being here. Thank you so much for hanging out. Feel free to hit the like button if you guys enjoyed the stream. And other than that, have a good one. Take care. Yeah, the Diddy trial's gonna be insane. Yeah, but it is a federal case though, so we're not gonna get any televised anything. Man, I really do wish like for some of the federal cases they would televise some stuff, you know? But it's a federal case, so we're just gonna be reading lots and lots of reading for that one. But yeah, that's about it. Will we see Unhinged Corgi later? I gotta pack, and then I have there's a birthday we want to go to. I don't know, maybe, possibly. I don't think so. We'll see. Bye, Ms. Mentats. Bye, Tam Tam. Bye, Hannibal. Yeah, I hope you guys have a good day. I will see you guys. Bye, Karina. Bye, Christine. Looking good for her fans. I will find that link. And yes, Sarah, yes, if you do find it, please. Thank you. I will appreciate that, because that would be kind of interesting if, you know, the expert opined on Sarah Boone's case. But I guess they could always say that, oh, you know, when I was on the Court TV panel, I said that she didn't qualify for battered, you know, spouse syndrome. But now that I've met with her and I reviewed her case, I actually changed my mind and she actually does. So maybe they'll say that. Maybe. I don't know. Maybe there's some information that will make them change their mind. Judge K needs a stiff drink tonight. Look at his face. He's just like, ugh. I'm tired. But you know what? I think Judge Craddock is one of my favorite judges. I think he's up there in terms of really great judges. In terms of patience and efficiency and just want to get straight to the point. I think he's up there with Judge Penny. Yeah, I really like him. All right, y'all. Have a good one. Take care. I'll see you guys later.